The following 4 hours you're about to watch is really the sauce. I'm giving you all the game to help you fix your credit. We're going to be going over the Fair Credit Reporting Act, which is 15 USC 1681, if you've never heard of it. And then we're going to transition into the FDCPA, which is 15 USC 1692. So this is what you're going to use against the debt collectors as they're harassing you. I'm literally giving you all the sauce. I've never put this out publicly before, so I just wanted to do a different type of video. Just give y'all all the sauce so you have no excuse not to get to the next level. If you enjoy it, if you get value from it, if you want to get more information, you can click the link in the description and then join our community Cat Credit University for only $39 a month. Enjoy the video. All right, listen, my name is Michael Benjamin. I think all of y'all know that. But basically, we're going to be doing a consumer law breakdown of the FCRA, the Fair Credit Reporting Act. I want to thank y'all for showing up tonight because, not everybody invests in themselves. So definitely appreciate y'all being here tonight. I definitely appreciate y'all participation. I know y'all going to participate. If y'all got any questions, definitely type them in the chat. Some of y'all are only typing to me personally, which is fine. But if you want to change your settings, you can type to everybody. I know we got some older people here, so maybe you never use Zoom. So if you got a kid around you, maybe that can help you. But it's okay if you just want to type to me. And if you got questions, I'm going to read them out loud to everybody that is attending. So yeah, with that being said, I'm going to share my screen and then we're going to get straight to it. Let me know if y'all can see my screen. Type a 2 in the chat if y'all can see my screen. Type a 2 in the chat if y'all can see my screen. I just want to make sure y'all can see it. Let me make sure that y'all can see it. I know y'all can hear me. So I'm gonna need full participation if we gonna, move forward how we can. Can y'all see my screen? Type a 2. Type a 2. Type a 2 below if y'all can see my screen. Type a 2 if y'all can see my screen. I don't know if my thing's delayed or y'all not typing to me or what's going on. Y'all see my screen? It says I'm sharing though, so I'm assuming that y'all can see it. Participation, please. Okay, 2. Okay, perfect. You can, okay, I think you can hear me now too. All right, so let's get straight to it. Okay, 2. Okay, cool. If you can't see my screen, get the recording. All right, let's get straight to it. So this is a consumer law breakdown, the FCRA, presented by Michael Benjamin, yours truly. Like I said, I'm the CEO of Consumer Ammunition Tactics, or CAT. That is the logo. Y'all know what it is. Let's get straight to it. I want to just get y'all straight to the point. We're not going to be here all night, but we're going to be here enough just so y'all will understand the language of the law. So housekeeping rules. The main rule I need y'all to understand is that y'all just need to take action, right? When I say take action, I mean that it's going to be a lot of information that we're going to go over as far as the laws, but y'all got to really understand to be persistent, to be consistent with all the information I'm giving y'all, right? So that's mainly the main rule. I just want y'all to take action. Y'all took action by being here, investing in the class. So I definitely appreciate y'all. And those of y'all watching the replay, y'all invested in the replay. So I also appreciate y'all too. All right, so the agenda. This is basically what the agenda is looking like. So pretty much we're going to break down the FCRA, which is 15 USC 1681. We're going to go in order of the laws I think are most important. So just really keep that in mind. 15 USC 1681, Congressional Findings and Statement of Purpose. If y'all want to screenshot this, you can screenshot it just to know what we're going to go across and cover. Then we're going to go into the definition section. The definition section is very, very important. It's very, very important in terms of y'all getting y'all deletions. So really keep that in mind. Then we're going to go to 15 USC 1681B, permissible purposes of consumer reports. Remember, these are not credit reports. These are consumer reports. Keep that in mind. Then we're going to go to 15 USC 1681C-2, which is a block of information resulting from identity theft. I want y'all to really be familiar with that section, and we're going to cover it. I'm going to let y'all know what I want y'all to take from that section, because I want y'all to really master deletions. As a result of everything y'all learning tonight or reviewing tonight, y'all can start your own credit business. You can host your own class breaking down the FCRA to people. So really keep that in mind. Then we're gonna go into 1681N, which is a civil liability for willful noncompliance. Then we're gonna cover 1681O, civil liability for negligent noncompliance. Then we're gonna cover 1681S-2. I'm gonna cover something that I like as far as like a second round dispute. A lot of y'all see what I be posting on social media. You probably saw the reel when I was talking about 1681S-2 in your second round. So we're gonna cover that. So basically it talks about the responsibilities of furnishers of information to consumer reporting agencies. CRAs are basically Experian, TransUnion, Equifax, those people, right? So once we break down all the laws and the language of the law, we're gonna go into a deletion letter example. I saw that some of y'all purchased some of the letters. Some of y'all purchased payment deletion letter. Some of y'all purchased the bundle. Some of y'all purchased the debt validation. So we're gonna go over an example and just break it down a little bit even more, just so it really crystallizes in y'all mind. Then we're gonna go over an affidavit of truth example. A lot of y'all DM me about affidavit of truth, so I decided we're gonna include that here. We're gonna go over just the components that's included in an affidavit of truth. We're gonna move forward on that. Then we're gonna go towards a process towards deletions. It's not, this is the only process, it's a process. So that's why I want y'all to recognize. So that's what we're going over tonight. All right, how do I move forward? All right, mindset. So this is where I need y'all to take action. When I say take action, take action. So I need you to write down on your piece of paper, on your notes, on your laptop, whatever you got for notes, right? Don't be writing it down in your mind. Write this down. I, and then insert your name, understand that everything I was taught about credit before may not have been true. And I promise to open my mindset to what I learned today. I, insert your name, understand that everything I was taught about credit before may not have been true. And I promise to open my mindset to what I learned today. Sign and then insert your signature. When you're done writing that down, say done in the chat. Let me know done in the chat. I'll give y'all like 30 seconds or something. I just want y'all to really be in that mindset where you're taking action, right? So I need y'all to do that real quick and then type a done in the chat once you're done doing that. Type a done in it. I'll put like 30 seconds or something. I'll put like 30 seconds, something light. I need y'all to take action. Action takers are money makers. And when you take action, you're going to be getting them deletions. If you want to get them deletions, you got to take action. If you want that money, you got to take action. So write that down, type it down, do whatever you got to do that's necessary. When I see like half of y'all say done, we're going to move forward. Y'all love typing the hosts and panelists. Type a done when you done writing that down. Type a done when you done writing that down. Type a done in the chat when you're done writing that down. Okay. Okay, we're gonna continue. All right, so any questions for me before we move forward? Just any immediate questions? I know we ain't covered the laws yet, but if y'all have any like immediate questions, definitely type them down below and let me know. Any immediate questions? Let me know if y'all have any immediate questions. Any immediate questions? Let me know. Will there be a replay? Yeah, when you went to actually buy the class, there was an option to purchase a replay. If you didn't purchase it, you'll still have an option to purchase it. So yeah, just keep that in mind. There will be a replay. Any other question before we start getting into the law? Does anybody have any questions? Any immediate questions? Will we be covering remedy? No, we're not going to cover remedy in this specific class. This is just breaking down the FCRA, but we will be doing a separate class where we will cover remedy. That's part of the reason why a lot of people that actually applied to be in the class, I was just saying like they don't technically qualify because of the fact that, you know, they might have been studying law already. So yeah, just keep that in mind. I'll take one more question if y'all got one more question. One more question if y'all got one more question. One more question. Okay, hold on. So we're about to get into it, but I need to go to the bathroom real quick. So y'all can take a little bathroom break, give me like a minute or two, and then we gonna get straight to it. Okay, I'm back. We're gonna get straight into it. Let me stop sharing my screen. And then y'all, let me make sure y'all can hear me. You know, I stopped the voice and then I went back to it. Type a 1 in the chat if y'all can hear me. I just want to make sure this recording, you know, is on point. Type a 1 in the chat if y'all can hear me. Where my Zoom at? Okay, let me. Okay, actually type a 1 if y'all can see my screen. If you see 1681, 15 USC 1681. We got some West Coast people, we got some East Coast people. East Coast people, it seem like y'all sleeping. Type a 1 in the chat if y'all can see my screen. 15 USC 1681. Type a 1 if you can see. 15 USC 1681. Okay, you can see 15 USC 1681. You can hear me. Okay, cool. 1. Okay, 1. Okay, y'all love that host and panelists. All right, so we're gonna get straight to it. So 15 USC 1681. This is the Fair Credit Reporting Act. Fair Credit Reporting Act, right? This is congressional findings and statement of purpose. Let me just give y'all some background on what that means. So congressional findings and statement of purpose, basically it means that Congress found out that there was something wrong going on. Because they found out that there was something wrong going on, they decided to put out a law. And we're going to get into, you know, what they found. And this is really giving y'all the background to understand your power as a consumer within this United States corporation. When we say this United States corporation, you understand that the code, or you should understand, is 28 USC 3002. If you scroll down to number 15, it says the United States is defined as a federal corporation. What that means is that the United States does commerce, it does trading, right? You as a consumer, me as a consumer, we engage in commerce. So basically with the Fair Credit Reporting Act, anytime, like I said, anytime you see congressional findings, it means that Congress found something wrong that was going on. So when you see congressional findings, just think about what did Congress find wrong that was going on, and then what did they declare as their statement of purpose? All right, so let's get straight into it. So 1681, we're looking at accuracy and fairness of credit reporting. Accuracy and fairness of credit reporting. We can't even move forward yet. We got to break that down right away. The average person would just look at that and then they just gonna continue reading. Okay, accuracy and fairness of credit reporting. What does it mean to be accurate? Type in the chat below what you think it means to be accurate. What is something that is accurate? Type below what you think is accurate. Type below what you think is accurate. Type in the chat. Accurate is correct. Okay. Anybody else? So accurate is correct, right? So that is the definition. But when it comes to, okay, somebody said perfect. Okay, so perfect and correct, right? So those are both true when it comes to accuracy. But when it comes to the law, you got to understand that the law is a language. When I say the law is a language, accuracy, if you have a Black Laws dictionary, if you don't have one, I recommend y'all look into getting one. But accuracy is defined as a measure of value. When it comes to the Fair Credit Reporting Act, accuracy is defined as a measure of value. I need y'all to write that down. Accuracy means measure of value. Michael, what do you mean by measure of value? When I say measure of value, or what the law says when it says measure of value means you as a consumer, when you're reading this, you as a consumer defines what valuable means to you, right? When it comes to credit reporting, we understand that when things negative are reported, that's not valuable to us. Is it valuable to us to have a collection on our account and then we apply for something and we can't get it? No, right? So that means that that is not accurate. So when you see, anytime you see accuracy or accurate in the Fair Credit Reporting Act, I want y'all to think of measure of value. Just substitute measure of value. Don't even think about perfect. Don't even think about correct. You know what y'all said in the chat. Just think measure of value, right? So you see, it's already deep. The very first word, we got to break it down. So that's accuracy, right? And then it says fairness. What is something that is fair? What do you guys think fair means? Type down below. What does fair mean? Fairness or fair, whatever. What does it mean? We're going to really break down the law tonight. What does fair mean? Somebody said fair means fair. Hey, man, what does fair mean? What do you think fair means? What is fairness? Don't be Googling now. What does fair mean? Fair. Equal. Somebody said fair means fair. That's funny to me. Okay, so fairness. So when it comes to fairness and the law, it means somebody doesn't have an unjust advantage over somebody else. Somebody said be good. Okay, so somebody said be good. Somebody said fair means fair. So fairness basically in the law means somebody doesn't have an unjust advantage over somebody else. So somebody does not have an unjust advantage over somebody else. That's what you really got to understand when it comes to the law, when it comes to the Fair Credit Reporting Act. So y'all should know now, when we're looking at accuracy and fairness, don't think about what you were taught growing up. That's why I made y'all sign that mindset thing before. So accuracy and fairness of credit reporting. What is credit reporting? It's referring to the fact that you have these stuff on Experian, Equifax, TransUnion, right? So accuracy and fairness. We got to really, really break it down. We didn't even start reading the law yet. We didn't even start getting to what Congress was saying. So you got to really understand the language before you even get into reading it. Because if you don't understand the language, you're going to look crazy when you're sending out your disputes or your demands to try to get these negative items deleted. Does that make sense? So accuracy and fairness. When it comes to the congressional findings, we're looking at accuracy and fairness of credit reporting. Those are the two things we care about, accuracy and fairness. Accuracy is a measure of value. Fairness means someone doesn't have an unjust advantage over somebody else. But let me break that down even more if some of y'all are still missing out on what that means. So not having an unjust advantage over somebody else, that means the fact of if you have a collection, if you have a negative student loan on your report, doesn't Experian, TransUnion, and Equifax have an unjust advantage over you? They have an unjust advantage over you because they're sleeping good at night, but you're the one that has to deal with that. You have to deal with the negative item being on your report. So it's understanding these language, these words, that's going to allow you to be more, I don't want to say accurate, but more accurate, meaning correct in your disputes. So you'll get those negative items deleted and do what you got to do, basically. So accuracy and fairness. I want to really break that down to y'all so y'all can really focus on it. All right, so accuracy and fairness. I hope y'all took notes. I hope y'all understand that because we're going to be substituting these phrases, the language. So if you don't understand the basic, you don't understand accuracy and fairness, you're going to be lost. So yeah, keep that in mind. All right, let's continue. The Congress makes the following findings. Are y'all following? Y'all following before I even continue? Y'all understand the accuracy and fairness? Did y'all learn something? Did y'all review anything? Did y'all know about that before? Let me know if that's helpful. Accuracy and fairness. All right, so the Congress makes the following findings. Number one, the banking system, right? Let's focus on here. The banking system is dependent upon fair and accurate credit reporting. We got to stop right there. We're gonna break down these laws now. I'm telling you. So the banking system is dependent upon fair and accurate credit reporting. What is the banking system? The banking system is the fact that you have what's it called? The banks like Bank of America, you have Chase, all these people you're doing business with. That's the banking system. They said the banking system is dependent upon fair and accurate credit reporting. What do we define fair as? Fair means not having an unjust advantage over somebody. Accurate means a measure of value. Is it valuable to you as a consumer, right? So that's the banking system. The banking system is dependent. What does it mean to be dependent? It means that you need it. So the banking system needs fair and accurate what? Credit reporting. And we're not even supposed to be covering this, but let me show y'all something about these banks real quick. So I just want to show y'all the power of these banks. So look at this law real quick. 12 USC 1431. Can y'all see that? 12 USC 1431. We're not even supposed to cover Title 12, but we're gonna cover it real quick. So I want y'all to look at the very first word right here. It says borrowing. Banks are borrowers. This goes into the fact that you are the original creditor. You originated that credit. We're not going to break it down too much because we're going to have a separate class on TILA, Truth in Lending Act. But I want y'all to understand that you guys are the consumer. You're the most powerful piece on the chessboard. You guys originated a credit. So I really just need y'all to understand that banks are borrowers. Banks are borrowers. Banks are borrowers. Write that down. Banks are borrowers. You originated a credit and then they loan you something that was originally your own credit. So just really understand that these banks aren't as powerful as you think they are. I believe I dropped a podcast episode on that, but yeah, I just want y'all to understand that. So let's go back to it. The banking system, right? These banks, their system is dependent upon fair and accurate credit reporting. But what is the definition of credit? A good habit I want y'all to have when it comes to reading these laws, when you see a link like this, click it, just click it. So it says credit. Credit and creditor. The terms credit and creditor have the same meanings as in section 1691A of this title. Okay, so if I'm reading the law, I'm gonna be like, okay, I see 1691A of this title. Let me go to 1691. Let me see what it's talking about, right? So I'm gonna go to 15 USC 1691. Or we said 1691A. So 1691A, right? Are y'all following? Am I going too quick? Y'all let me know below if y'all following, right? So we're looking at the term credit, and this is in D. So the term credit means the right granted by a creditor to a debtor to defer payment of debt or to incur debts and defer its payment or to purchase property or services and defer payment therefore. What does all that even mean? So credit basically just means that you have a right granted and you're deferring payment. But the most important part I want y'all to really understand from that definition is right. Credit is a right. Credit is your right. Credit is my right. It's your right. Somebody can't take something that's your right from you. So how are they going to tell you you could be denied from something? That goes into adverse action. I dropped a podcast episode on it. Y'all can go listen to that if y'all want. But I want y'all to understand that credit is your right. Credit is your right. That's the main thing I want y'all to understand from that. So we said the term credit means the right granted, but it says by a creditor. What did I tell y'all earlier? When you see a hyperlink like this, just click on it, right? The term creditor, let me go back. So the term creditor is just right after, right? So the term creditor means any person who regularly extends, renews, or continues credit. I'm gonna just stop there. We're not even gonna read the whole thing because we're gonna get back to the FCRA, but you see right here, any person, right? So let me click on person because I want to know what that means too. I think it's right after. So yeah, the term person means a natural person, a corporation, or a government or governmental subdivision or agency, trust, estate, partnership, cooperative, or association. So you can get in a rabbit hole reading these definitions. I just want y'all to have these best practices of constantly looking to figure out what you're reading. So we see person means a natural person here, right? Natural person just means that you were born naturally from your parents. You have a mom, you have a dad, they created you. That's what natural person means. A corporation can be the fact of you have a bill, you see your name in all capital letters. A corporation can be, Experian and all those people, right? So just really understand it's a language of the law. And there's different definitions per section. So when it comes to like consumer is defined as an adjective in the Truth in Lending Act. Consumer, we're going to look at the definition of consumer here in the Fair Credit Reporting Act, but consumer means just an individual in the Fair Credit Reporting Act. So you see that there are different definitions of the same word. This is why you got to understand that the language is a law. That's the main thing I want y'all to understand. Let me know how y'all feeling. Am I going too quick or y'all following? Am I going too quick or y'all following? So we're going to go back to the Fair Credit Reporting Act. We're going to go back to the Fair Credit Reporting Act. Let me know how y'all feeling. Y'all good? Y'all good? Y'all good? Y'all good? So we were talking about the banking system, right? We only went through the very first sentence, right? So the banking system is dependent upon fair and accurate credit reporting, right? So we finished that sentence. We recognize that credit means the right granted. Credit is your right, remember? And an accuracy is a measure of value. And then fairness, something that's fair means someone doesn't have an unjust advantage over somebody. So just really understand the language, understand these definitions. If you need a purchase, if I'm going too quick, definitely recommend you purchase a replay if you didn't already, and then just break it down piece by piece. All right, let's go to sentence number 2. Inaccurate. Before we move forward, accurate means what? A measure of value. So something that's inaccurate means it's not valuable to you as a consumer, right? It's not valuable to you as a consumer. So inaccurate, something that's not valuable to you. Credit, you're right. Something that's not valuable to you, you're right. Reports directly impair the efficiency of the banking system, and unfair credit reporting methods undermine the public confidence, which is essential to the continued functioning of the banking system. There's a lot said right there, right? So inaccurate means something that's not of value to you. Credit, the right, directly impairs the efficiency of the banking system. We already said the banking system is you doing business with Chase, Bank of America, all that, right? When you're applying, you're doing everything you got to do because you are, you're the consumer, you're the most powerful piece on the chessboard. So when you have something that's inaccurate on your credit report, something that's not of value to you, you determine that it directly impairs. What does impair mean? Diminishes the value. It impairs the efficiency. What is something that's efficient? Something that's working, right? Of the banking system. And unfair. What does unfair mean? We said fair means having a not having an unjust advantage over somebody. So unfair means having an unjust advantage over somebody. And unfair credit reporting methods undermine. What does undermine mean? Diminish the value. Undermine the public confidence. Public confidence is us being confident to do business with Bank of America, Chase, Navy Federal Credit Union, all these people, right? Undermines the public confidence, which is essential. What is something that's essential? Something that's necessary. Essential to the continued functioning of the banking system. What does it mean to function, to work? So basically what they're saying is that Congress found out that there was unfair practices when it comes to credit reporting, and they understood the fact that we are the most powerful people, the consumers. So if we don't want to do business with them, it's not going to work. That's what you need to get from number 1. I want to really break it down so y'all really understand it. So when y'all doing y'all disputes, you understand what you're looking at. Let's go to number 2. An elaborate mechanism. Let's pause right there. So Congress is being very disrespectful right here. They said an elaborate mechanism. What is an elaborate mechanism? An elaborate mechanism basically just means that Congress is saying that these consumer reporting agencies, meaning Experian, TransUnion, Equifax, they appear to be bigger than what they actually are. They appear to be bigger than what they actually are. If you call someone an elaborate mechanism, you're basically saying that they're trying to be bigger than what they are. An elaborate mechanism has been developed for investigating and evaluating the credit worthiness. What do we say credit is? You're right, right? So an elaborate mechanism has been developed for investigating and evaluating your rights worthiness. Your right, standing. Your right, capacity, character, and general reputation of consumers. How can somebody evaluate you on something that's your right? That's basically what Congress is saying. They're calling them an elaborate mechanism. These people are pretending to be bigger than what they are. And they're evaluating on you on something that's your right. That doesn't even make sense. That's what y'all got to really understand when you're going through the FCRA. And then we see here the term consumers, right? What did I say earlier? Consumers is defined differently in different sections. I said the FCRA means what? An individual, right? In the Truth in Lending Act, consumer is defined as an adjective. In the FDCPA, or Fair Debt Collection Practices Act, 15 USC 1692 is defined as any natural person that has an obligation or an alleged obligation to pay a debt. So this is just more evidence that the same word can be used and defined in different sections. So you got to really understand where you're at. On top of that too, the Truth in Lending Act is for credit. The Fair Credit Reporting Act is for credit reporting. So really understand the difference. Everything is a language. I really want y'all to remember that and understand that. So an elaborate mechanism has been developed and, for judging the reputation of consumers. You and I are consumers. So let's go to number 3, consumer reporting agencies. What is a consumer reporting agency? Experian, TransUnion, Equifax. A lot of people be like, oh, they're bureaus. They're not bureaus. The only bureau is the Consumer Financial Protection Bureau, the CFPB. We're going to go over them a little bit today. I'm going to show y'all some examples and things like that. So consumer reporting agencies have assumed a vital role in assembling and evaluating consumer credit and other information on consumers. Consumer reporting agencies have assumed. What does it mean to assume something? They've assumed a vital role. They've assumed a vital role, meaning that the role wasn't given to them. They're just assuming that they're it. If I assume I can fly, does that mean I can fly? That don't mean I can fly. I just made an assumption I can fly. If I assume that I'm the president of the United States, am I the president? I'm not the president of the United States. I just made an assumption. An assumption isn't always true. So that's basically what Congress is saying right here. They said Experian, TransUnion, and Equifax, they've assumed a vital role. What does it mean for something to be vital? It's a life or death situation. They've assumed a role that is life or death because the banking system, this whole corporation is dependent upon us, the consumers. A vital role in assembling and evaluating consumer credit and other information on consumers. So that's what they're saying right there. Number 4, this is the last one we're going to cover, and then we're going to go into the definition section. So number 4, there is a need to ensure that consumer reporting agencies exercise their grave responsibilities with fairness, impartiality, and a respect for the consumer's right to privacy. There's gold right here in what we're looking at. So number 4, there's a need to ensure that consumer reporting agencies, so Equifax, TransUnion, and Experian, there's a need to ensure that Experian and them exercise their grave responsibilities. What does grave responsibility mean? Again, it's a life or death situation. Their grave responsibilities with fairness. We defined fairness earlier, right? Fair means not having an unjust advantage over somebody. Fairness, impartiality, same thing. And a respect for the consumer's right to privacy. That's gold right there. You as a federally protected consumer, you have a right to privacy. So we're going to get into as far as like the weapons I would use when it comes to issuing your demand in your dispute letters, but there's gold right here. So a lot of times y'all have heard me on the podcast or on social media, I'll be like 15 USC 1681B number 2 talks about written accordance of the consumer. But one hack you could do, you could literally just start right here in the congressional findings. You could quote 15 USC 1681A4. A4 says, I as a consumer have a right to privacy. So by them publishing information, a collection, a medical bill, that's a violation, right? So you could use that as ammo when it comes to your dispute letters. Before we move forward, any questions on this page? Let me know how y'all feeling. Are y'all taking notes? Are y'all getting value? Let me know below. Let me know below. Participate. Y'all sleeping? Let me know how y'all feeling. Y'all good? Let me know. Let me know if y'all good. Let me know if y'all good. Can y'all hear me? Let me know if y'all good. Let me know if y'all not good. Let me know. Let me know how y'all feeling. Type down below before I continue. Let me know if y'all good. Y'all good? That was a mouthful. Let me know if y'all got any questions about this section so far. Any questions? Any questions? Let me know how y'all feeling. Okay, good. Y'all ready to move forward? All right, we're gonna go to the definition section. All right, so 15 USC 1681A, definitions. Definitions, rules of construction. So we're gonna go over the main definitions that I think you should know, and then we'll move forward from there. So basically, the term person means any individual, partnership, corporation, trust, estate, cooperative, association, government or governmental subdivision or agency or other entity. The term person means any individual. What does any mean? Any means no restriction. When it comes to law, you got to understand that any means no restriction. There's no restriction to what we're talking about. That's why I want y'all to understand. Any individual, right? Person means any individual. So any individual can be you. Any corporation can be Experian, TransUnion, Equifax. Y'all got to really understand the definitions when it comes to you know what we're talking about. The term consumer means an individual. Remember, I said consumer means different in different sections. So really understand what you're reading when you want to construct your demand. So consumer report. The term consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's credit worthiness, credit standing, etc. Right? The main thing I want y'all to understand right there is your consumer report is basically like your credit report. So really understand that too. And then what I want y'all to really understand is the exclusion section. So if you see exclusions right here, we're going to read the exclusion section and look at one of them. So except as provided in paragraph 3, the term consumer report does not include. Last time I checked, does not include means it's not supposed to be included. So the term consumer report does not include, right? Does not include. It does not include a report containing information solely as to transactions or experiences between the consumer and the person making the report. Remember, it's definitions. Between the consumer and the person making the report. So a lot of times when you're constructing your argument or your demand, your letter, you want to look at 15 USC 1681A 2AI. You want to use this section right here, 2AI. You want to literally copy it and paste it in your template letter and be like, oh, you know, it's a violation because your transactions or experiences aren't supposed to be included in your consumer report. What is a transaction or experience? An experience is a fact that you took out a credit card with Chase. Why is it being reported to Experian, TransUnion, and Equifax when you have a right to privacy as a consumer? So that's an experience. The fact you apply for something, you have an inquiry, a hard inquiry, that's an experience. That's not supposed to be included on your consumer report. So that's a violation right there. So in your very first letter, you can use 15 USC 1681A 2AI in your dispute, and that can help you move forward as far as, you know, your argument. So keep that in mind. All right, so that's 2AI. I want y'all to realize that. And then B. So 15 USC 1681A 2B. Remember, we're still in the exclusion section. So it means what's supposed to not be included in a consumer report, right? So any, when you see any, the word any means no restriction. Any authorization, or when you see the word or in law, it means you can choose either side you want to be on. Any authorization or approval of a specific extension of credit directly or indirectly by the issuer of a credit card or similar device. So when it comes to credit card, the term credit card has the same meaning as in section 1602 of this title. So that's truth in lending. We're not supposed to be focused too much on truth in lending, but I just want to show y'all, you know, the definition section. I want y'all to be in a habit of going to these sections when you see a new word and just read what it says. So 1602L is what a credit card is defined as. It just basically means any card, plate, coupon, book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. So any card, any means no restriction, like I said. Your license plate is a credit card. Your social security number is a credit card, right? That's the whole point of that. Your social security card or social security number meaning that was what you used in a transaction when you're able to get that credit. That's what they're talking about in the exclusion section. Any authorization or approval of a specific extension of credit directly or indirectly by the issuer of a credit card or similar device. What they mean right there is that when you use your social security number, which is an open-end credit plan, to go ahead and apply for something, when that information was reported to your report, whether in the form of an account, inquiry, or whatever, that's not supposed to be included on your credit report. So when you see people using the law to get negative items deleted, they understand this. 1681A to B is part of the exclusion section. So I want y'all to use that as well. So write this down, 15 USC 1681A to AI, which talks about transactions and experiences. And then 15 USC 1681A to B, which talks about authorization or approval of a specific extension of credit. And that's basically the use of your credit card or social security number. So yeah, just keep that in mind. I believe that was all I wanted y'all to know on this section. You guys know the term consumer reporting agency. Okay, let's look at the term file real quick before we continue. The term file, when used in connection with information on any consumer, means all the information on that consumer recorded and retained by a consumer reporting agency, regardless of how the information is stored. The reason why I want y'all to understand file is that there's a difference between your credit report and credit file. You can send a letter to Experian, TransUnion, Equifax, and be like, I'm requesting my credit report. But you can also request your credit file. Your credit file has more information on you that they have on you. So really just understand that you can request your credit file, you can request your credit report. They're different things. So you got to really understand how these consumer reporting agencies are violating you, because they have a lot of information that they're reporting on you that they're not supposed to be reporting on you. I think that was all I need y'all to understand in this section. Yeah, that was all I need y'all to understand in this section. So the next law we were going to go to, I think it was, it's B, 1681B. So let's see if they'll allow me to move forward. Let me know how y'all feel in the comments. Y'all good? Y'all following? Okay, they starting that nonsense now. So I got to go over here. So y'all good? Y'all following me? Any questions? Let me know if y'all good. Let me know if y'all good. If y'all following me, y'all sleeping, let me know. Let me know in the comments below. All right, so 1681B, permissible purposes of consumer reports, right? Permissible purposes of consumer reports. So when I said we're going through sections, I just want y'all to go through the main things I want y'all to know. The main sections I want y'all to know. So permissible purposes of consumer reports. Remember, your consumer report is your credit report. So the main section I want y'all to know is literally right here. Subject to subsection C, any consumer reporting agency may furnish a consumer report under the following circumstances and no other, in accordance with the written instructions of the consumer to whom it relates. What does that mean? It means that they cannot publish a consumer report unless they get your written instructions. Did you give Experian written instructions to publish that inquiry that you got from applying to a Bank of America credit card? The answer is no. Did you give them written instructions to publish, that negative account, those late payments? The answer is no. So that's a law that you can use as far as your weapons too, when it comes to disputing this negative information or demanding your information be deleted from your consumer report. So that's one thing I want y'all to realize. That's all I want y'all to take from that section. 1681B number 2, it just says that they have to have your written instructions to publish anything, to furnish anything on your consumer report. So keep that in mind. So when you understand that, basically anything can be removed from your consumer report. You as a consumer, you have a power to understand what needs to be reported, what doesn't need to be reported, because you have a right to privacy. Remember that. All right, so now I want to go to 1681C-2, which is the block of information resulting from identity theft. Y'all good? Let me know below how y'all feeling. Participate. Let me know how y'all feeling. Let me know how y'all feeling. Let me get a water break before we continue. We get a water break. Y'all following or y'all sleeping? If y'all sleeping, just let me know. Well, if y'all sleeping, y'all gonna be sleeping. All right, 1681B. Yeah, it's 1681B number 2. Oh, you said go back. It's 1681B number 2. 1681B2. I believe you purchased the recording. So yeah, you can just watch the recording. Go back at 1681B number 2. Y'all good? Are we gonna continue? So 1681C-2, block of information resulting from identity theft. This is an important section. I need y'all to really understand. A lot of y'all be DMing me about, FTC reports and inquiries. So you want to really pay attention here. So block is what I need y'all to understand. Except as otherwise provided in this section, a consumer reporting agency, what is that? Experian, Equifax, TransUnion. A consumer reporting agency shall block the reporting of any information. What did I say any means? No restriction. Any information in the file. What did I say file means? Or what did the law say file means? It's different from your credit report. Your file has more information on you. Any information in the file of a consumer. What is a consumer? An individual. That the consumer identifies as information that resulted from an alleged. What does an alleged mean? Something that possibly could have happened. Identity theft. Identity theft based off of the law means no consent. Did you give them consent to publish that information, publish that inquiry? The answer is no. Not later than 4 business days after the date of receipt by such agency of appropriate proof of the identity of the consumer, which is what you submit with an FTC report, a copy of an identity theft report, which is the FTC report, the identification of such information by the consumer. So the account you want to remove, the inquiry you want to remove, whatever. A statement by the consumer that the information is not information related to any transaction by the consumer. So, your personal statement section when you write an FTC report. So I want y'all to have block of information in y'all tool belt because of the fact that it's an important section. And it says right here, I want y'all to really realize not later than 4 business days. How can we calculate that they have to, delete the information not later than 4 business days? We send a certified mail. When you send something certified mail, they have to sign that they received it. So if they don't delete those inquiries that you submitted an FTC report for, or those accounts that you submitted an FTC report for, you've already trapped them in a violation. And then we're going to go to the section later on in terms of what you can use for violation. 1681N, 1681O, you have a couple options in the FCRA. So 1681C-2, block of information resulting from identity theft. I just want y'all to not be scared about identity theft because from a law standpoint, it means no consent. You didn't give them consent to publish information. And then what's important too is an alleged identity theft. Congress is giving you power here. Even if it wasn't identity theft, it's alleged identity theft. I can't tell you what's an alleged identity theft. Me personally, if I go apply for something tonight, let's say I go apply for a credit card with Navy Federal tonight, I get an inquiry on my TransUnion consumer report. If I want to remove the inquiry, that's an alleged identity theft, right? I know I did it, but that's an alleged identity theft. So y'all got to really understand the language that Congress is throwing you. Congress is giving y'all, they're throwing y'all an alley-oop. You just got to dunk it. You just got to understand the language. So really understand that. And that's going to help you with your demands. So I encourage y'all, if all of this is a little bit fast for you, just watch the replay and then you'll be able to master it and master your deletions. So really understand, not later than 4 business days. If it's the 5th business day, bring them to 1681C-2. Let them know that, right? When I was getting cars for Turo, y'all know I do cars for Turo, and I was getting a lot of inquiries because I had financing through Bank of America for business, but then I was at a place where I had to get it in my personal name. So the Bank of America business auto loan approval that I had didn't work for that particular situation. So I had to run, the credit or whatever, but I already knew I could remove the inquiry. So I just let them, because I like to test out different things. So once that happened, I submitted a FTC identity theft report. I understood the block of information. And, I called them once they received it. I literally read the law to them. And luckily for them, they didn't do a violation because it was gone within the 4 business days. But sometimes it takes breaking down the law to these people to let them know, what it is. So really just, put this in your tool belt and that will help you move forward. What was the next law I wanted y'all to understand? C-2. Okay, yeah, we're going to the remedy section. Someone asked earlier, are we covering remedy tonight? We're not covering remedy, but we're gonna go over the section you can use. because I don't want to overflow y'all with information, and we can do a separate class on remedy. So we need debt collectors and things like that. We're gonna save all that for the mentorship though. But you know, just keep that in mind. All right, so 15 USC 1681N, civil liability for willful non-compliance. Before I continue, any questions? That's me wanting to take a water break. I'm talking like crazy. Any questions? All right, let's continue because we got some other things we got to cover. I don't want to keep y'all here all night. 1681N, civil liability for willful non-compliance. So willful non-compliance, what does that mean? You're willfully not compliant. So in general, this is what we're going to read real quick. Any person, remember what we said person means earlier? It could be a corporation, it could be an individual, it could be whatever. When we're looking at person, we're looking at Experian, we're looking at Bank of America, we're looking at the people that violated us. Any person, any means no restriction. Remember that. Any person who willfully fails to comply with any requirement imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of what? Any actual damages. So A1A is your sauce. B has some even more sauce, but A1A, any actual damages sustained by the consumer as a result of the failure or damages of not less than $100 and not more than $1,000. So in A1A, they're saying the damages that come to you can't be more than $1,000. Why do you think Congress said that? You got to read between the lines. The reason why Congress put that there is because they understand that you could be violated way more than $1,000. Let me give y'all a scenario. Let's say I'm in a situation where I have a late payment. Let's say I have a late payment and it stopped me from getting an approval for a house. Is any house going to be just $1,000? That damage is going to be way more than $1,000. What if I lost out on $500,000 house? So Congress, by putting that A section, they understand, they limited, the damage because they understand the fact that you're going to sustain damages that are greater than $1,000. What if I'm sleeping at night and I'm just like, dang, I got a denial. And, I have mental damages. I have mental anguish. I'm scared to see what's on my consumer report. Mental damages are going to be way worth more than $1,000. So just really keep that in mind and read between the lines in the civil liability sections. So let's go to B though. B is even, more sauce. So in the case of liability of a natural person for obtaining, okay, let's go back to what it said earlier. Any person who willfully fails to comply, right? In the case of liability of a natural person for obtaining a consumer report under false pretenses or knowingly without a permissible purpose, actual damages sustained by a consumer as a result of the failure or $1,000, whichever is greater. So when it comes to the civil liability section for willful non-compliance, you want to use section B. Why do I say that? Let's go back to my example with the house. They said it's going to be a damage of $1,000, but whichever is greater, right? If I lost out on a $500,000 house, is that not greater than $1,000? So you got to understand the language that Congress is saying. Congress tossed you to alley-oop. It's just for you to understand what's going on. So when you are talking about civil liability section, let's say you're not getting, your desired result as far as the deletions. Because number one, I want y'all to focus on deletions. Focus on deletions, and then you can go for the money after. Focus on deletions first. Master the deletions. So let's say they don't want to remove an inquiry, right? You're going to bring them to the civil liability section. You could use A and be like, oh, it's going to be $1,000. Or you could even use B and be like, this inquiry stopped me from getting an approval. Now I'm on the streets or something. I wasn't able to get my house or something like that, right? Just really point them and let them know that whichever is greater portion of it, and break it down to them. You got to break it down to them because most people don't understand these laws or what they even mean. So you got to really break it down in layman's terms. And that's the whole purpose of this introduction class. We're going to have a separate class, like I said, as far as remedy. I have a client right now that's being sued. But yeah, we're gonna go through that and just the process of how I would go about that personally. So yeah, that's 1681N, civil liability section. Have this in your tool belt. and understand that the civil liability section in the Truth in Lending Act is 15 U.S.C. 1640. Civil liability section in the Fair Debt Collection Practices Act is 15 U.S.C. 1692K. So both of those sections, Fair Credit Reporting Act or Fair Debt Collection Practices Act and Truth in Lending Act, both of those sections have one apiece, civil liability section. But the Fair Credit Reporting Act is special because they have two. They have 1681N, they have 1681O. Let's see if they'll let me go right away to it. Okay, yeah. So civil liability for negligent noncompliance. So not only can you hit them for willful noncompliance, you can hit them for negligent noncompliance. You're being negligent if you're not deleting that item I told you to delete after I proved to you that it's inaccurate. What is inaccurate? Something that is not of value to me as a consumer. Remember, accuracy means a measure of value. We're not talking about correct. We're not talking about something that's right. We're talking about Black Law's Dictionary. Accuracy is a measure of value. Is it valuable to you as a consumer? Is it valuable to have an inquiry that's holding me back from getting what I need to get? That's a question you need to ask yourself. So any person who is negligent in failing to comply with any requirement imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of, listen, any actual damage sustained by the consumer as a result of the failure, right? So any actual damages. So again, they're just reiterating the fact that you can get these furnishers of the information, meaning like Bank of America, whoever put the inquiry, or these CRAs, consumer reporting agencies, you can get them in trouble based off of these sections if they're failing to delete the information you tell them to delete. So second one is important too. In the case of any successful action to enforce any liability under this section, the cost of the action together with reasonable attorney's fees as determined by the court. So I wouldn't necessarily use number 2. I just want to point it out to you because it says in the case of any successful action. Why is that different from number 1? Number 2 is different from number 1 because number 2 has to be a successful action. So you have to be successful in, your debate with the court. But number 1 says any actual damages. You as a consumer, you're always successful because you define actual damages, right? So really keep that in mind. So I just want y'all to understand when it comes to number 2, it has to be a successful action. Not to say that it can't be a successful action, but to me, I like to go with what's easy. What's easy is I could just say, oh, I sustained mental damages. I wasn't able to get an approval for what I got. But with number 2, it has to be successful action. Successful action meaning that's determined based off of someone else's perception. You don't want to be in a situation where it's determined based off of someone else's perception. So yeah, keep that in mind. We're gonna go over one more law, and then we're gonna go to the next section. I believe that is S2. Let me make sure on my list right here. Yeah, S-2. Okay, so this one is some real sauce too. So this is the last law, and then we're gonna move forward. So 1681 S-2, 15 USC 1681 S-2, responsibilities of furnishers of information to consumer reporting agencies. We got to break that down first. Responsibilities of furnishers of information to consumer reporting agencies. So some people might read that and they think, okay, they're talking about Experian, they're talking about Equifax, they're talking about TransUnion. You would be half correct, right? So furnishers of information, that means Citibank, that means Bank of America, that means the people that actually put that information on your report. I had a call with a client, and I know some of y'all that, well, I think most of y'all follow me on social media. You've seen me say like I'm not doing consultations. So the consultation was with someone in my cat friend circle. So my cat friend circle, if you don't know, is my private IG community where I'd be giving out, weekly game and things like that. So that's why we had a consultation. It's not like I was just having a consultation to have a consultation. So I had a consultation with a client, and she was basically not knowing the fact that you can go after the furnishers of the information on your report, right? So I want y'all to understand that you don't only have to go after Experian, TransUnion, and Equifax. You can go directly to the furnishers of the information. And I would say it's even better if you go directly to the furnishers of the information, because you got to think about it. If you're in a situation where you have an account and that came from like Bank of America, or you have an inquiry and that came from Bank of America, you run directly to Experian, TransUnion, and Equifax, it's like, go take it with the person you have the problem with first. You know what I'm saying? So really understand. You can send these demands to the furnishers. You can send the demands to the consumer reporting agencies. So responsibilities of furnishers of information. So responsibilities of Bank of America to consumer reporting agencies, to Experian. Responsibilities of Bank of America to Experian. So that's how you should read the report. Remember, it's a language, so just substitute different words and phrases. I hope y'all taking notes so that you can look back on your notes, study it, and make these substitutions. I've been studying this stuff for, quite some time, so I might be going a little bit quick. I might not be going as quick for some of y'all too. So, but just really take notes, and then, you'll be on your way. All right, duty of furnishers of information to provide accurate information. What do we say accurate means? A measure of value, something that's valuable to you as a consumer. So prohibition, what is for something to be prohibited, what does it mean? Let me get some participation below. For something to be prohibited, what does it mean? For something to be prohibited, what does it mean? What does prohibition mean? This is me taking a water break. Isn't allowed? Perfect. Okay, yeah. So for something to be prohibited, okay, not allowed. Yeah, exactly. So isn't allowed, not allowed, however you speak, whatever, is the same thing. So for something to be prohibited, it means it is not allowed. It is not allowed. So reporting information with actual knowledge of errors. Let's get it. So a person, we defined person earlier. I've said it multiple times, so y'all should know what a person means. So substitute a person with Experian, substitute a person with Bank of America, whoever. A person isn't only you as a consumer. So a person shall not furnish any information relating to a consumer to any consumer reporting agency. So to Experian, if the person, so Bank of America, if Bank of America knows or has reasonable cause to believe that the information is inaccurate. There was a lot said right there. So basically says Bank of America, Chase, whoever you have a problem with, they can't furnish any information to Experian, TransUnion, Equifax if they know that the information is inaccurate. These furnishers of the information, they have the ability to remove, this inquiry and all that stuff from reporting. So really attack the furnishers of the information. Take the problem with who you have the problem with. It doesn't always have to be Experian, TransUnion, and Equifax. You can just send to them as extra measure for a paper trail if you want, if it goes deeper than what it needs to be. So the reason why I like this section right here, and we're gonna get into it in the actual the template letter. The reason why I like this section right here is because of the fact that you got to understand this part right here. Reasonable cause. This is my favorite part. This is my favorite part in how my clients have gotten student loans deleted. I had someone with a late payment. They got it reversed back to them. So yeah, this is really the sauce on how you get these deletions. So reasonable cause to believe that the information is inaccurate. How do you make sure that they have reasonable cause to believe that the information is inaccurate? You make sure of that by your first round being you define accuracy to them, and then you let them know that therefore the information is inaccurate. So what does this entail? This entails breaking down the law to them. So then you quote 15 USC 1681 S-2 A1A, and you show them, look, I sent you in my last letter, the fact of the matter is that this information was inaccurate. And now I'm sending you the second round letter, S-2, to let you know that you have reasonable cause to believe that the information is inaccurate. They have reasonable cause because you let them know in your initial letter that this information is inaccurate. And they can't say that they didn't receive your letter because you sent it certified mail and then you got that green return receipt. You see how this is a system? You want to trap them basically. So I want y'all to have the mindset of, I don't necessarily need to get my result in the first round or whatever. But to be honest, I had a client, she simply sent a debt validation letter and got a student loan deleted, but it doesn't always happen that way. Everybody's situation is different. But I want y'all to really understand, you want to set them up. So use 15 USC 1681 A4. Be like, oh, this is a violation of my right to privacy, so information is inaccurate. Use 1681 B number 2. written accordance of the consumer, right? This is a violation because I didn't give you written permission. Use the exclusion section, 1681A2AI, experiences and transactions, or 1681A2B, authorization or approval, right? I gave y'all 4 sections y'all can use in your first round. And when it comes to late payments, you can use 1666B, timing of payments, or you can use 1666, go down to B, correction of billing error. That's 6 different laws y'all can use as your initial round. And then you hit them with round 2, 1681S-2, right? Y'all got to really understand that. This is the language of the law. So like I said, if I'm going a little bit too fast for you, just play the replay and y'all will be able to really understand it. Just study it every day and y'all will understand it. So yeah, this is 1681S-2. I think that was all the laws I wanted to cover. Any questions so far before we move forward? We're going to move to a deletion letter example, and I'm going to break down more of what I was talking about as far as, the rounds. I think most of y'all at least bought one template letter. So what we're going to look at should be familiar to y'all. Let me know if y'all got any questions. Let me know. How y'all feeling so far? Are y'all following? Let me know how y'all feeling so far. If y'all following, if y'all good, let me know if y'all taking notes. Let me know if y'all gonna watch a replay. Let me know. Let me know if y'all sleeping. If you can, let me know. Let me know. Let me know how y'all feeling, or if y'all got any immediate questions. Let me know. Yeah, we're about to look at the template letters. Where can you purchase the template letters? So when you purchase the class, basically there were order bumps when you scroll down and they had deletion letters. I don't know, maybe you scroll past it. But if you go to catactisllc.com, we also have deletion letters, so you can go ahead and get deletion letters over there. And that should help. How do I remove a late payment? That is the only thing holding me back. Okay, so with the late payment, we're going to go over the template letter, and I'll give you an example. But what I've seen, like I said earlier, one of my clients, she literally sent a debt validation letter. Or I think that was for a student loan. It might have been for a student loan. She sent a debt validation letter and got it, removed. So just really understand everybody's situation is different. But if you figure out that, you can't do it by yourself, you can go to catactisllc.com. You could book a free credit repair consultation. We will get you handled and, go on about that. Feeling good? Okay, good. Got a lot of notes. Okay, good. That's perfect. I hope you study the notes. And I remember you purchased the replay as well. And I think you might have got the bundle. Did you get the bundle? I think you got a bundle too. Okay. So we're gonna look at the example. Majority of y'all are doing to hosts and panelists. I hope y'all know that you're not typing to everybody, which is fine, but ain't nothing wrong with that. I just want to let y'all know. Okay, let me get out of here. Okay, so the deletion letter example. So a couple of y'all already got this, but this is basically how I would construct an example deletion letter. So now that we understand the law, we understand the language of the law, we don't want to make it too deep. We just want to send them a simple letter to get this deletion letter removed. Do I always have to send an affidavit of truth? Okay, we're gonna get into affidavit of truth, but you don't necessarily always have to send an affidavit of truth. I'm gonna cover that in a little bit. So you're getting ahead of me. Relax. No, I'm playing. All right, so first of all, you want to put your name, your address, all that, and then you're gonna put the date, and then you're addressing to Experian or the furnisher of the information, whoever you want to address. So what I would put is to whom it may concern. And then I would put, I received a copy of my insert your report, whatever it is. It could be Experian, TransUnion, Equifax, whatever you got a problem with. And I noticed you're going to insert the negative item that needs a deletion. I noticed this that needs to be corrected. They are as follows. Put down the account number, put down the account. Very, very basic information. You're literally letting them know. I noticed something on my report. This needs to be deleted. and we're making a demand. We're not making a request. This is a demand. I want y'all to have that mindset. So then you immediately let them know your company is in violation of the Fair Credit Reporting Act, otherwise known as 15 U.S.C. 1681. One thing I want y'all to know too, with template letters, I don't want y'all to just copy what it says verbatim. Plug in your own words. Template letters are meant to be a guide in terms of how you should do it. And I used to actually not even sell template letters just because I was, worried that people would just copy it verbatim. And I had these template letters for a while, but it's just that when I was on consultation calls, I would just tell people how I would, construct it. But y'all getting the information as far as looking at it here. And I know some of y'all purchased them already. So I just want y'all to be responsible with how you actually use the template letters. So let them know they violated the FCRA. Then what the best practice that I like to do is literally copy the law and break it down to them. So this is a round 2 letter that we have as an example. You see it's S-2, responsibilities of furnishers of information to consumer reporting agencies. I would say the law clearly states and then publish it, right? Copy and paste it. Does that not look familiar? We just talked about prohibition. Don't make it too deep. So then I'll explain it to them, right? So like I said, this is an example of a round 2 letter. So let's say we sent our first round, we sent a debt validation. We sent, just for the sake of example, we use 1681B number 2 in our example for round 1, saying that our late payment needed to be removed because we didn't give them written instruction. Or we use 2AI because that was an experience or transaction between us and, the person. So this is round 2, like I said. So clearly, prohibition means something that is not allowed. This law says a person, you in this case, shall not furnish any information relating to a consumer to any consumer reporting agency if the person knows or has reasonable cause to believe that information is inaccurate. So you're just letting them know what they're doing. You want to coach them through, the law. Somebody asked, why are there highlights? Okay, I should have said that too. So as far as the highlighting, the reason why I'm highlighting is when you're sending dispute letters to Experian, TransUnion, and Equifax, there's something called the eOscar system. The eOscar system means that when your dispute or your demand is sent over to them, they have an automated system, an automated system that scans your letter. And our whole goal is to get our dispute to a human being. How can we get our dispute to a human being as best as possible? What we could do, we could throw them off by highlighting random phrases and words and things like that. So that's really the reason why I'm putting the highlights, because I want y'all to bypass the eOscar system, get directly to Experian, TransUnion, or Equifax, or whoever you're dealing with. Because you got to realize it's billions of consumers. They're not going to be reading your dispute all the time. But most people don't understand the fact that there is an eOscar system. So most people are going to get that automatic thing of, oh, this information is verified. Whole time it wasn't even a human being that looked at your letter. So you want to really think about what are tactics, consumer ammunition tactics, that we could use to bypass the eOscar system. So that's why there's a highlight. That was a great question. All right, so then you walk them through it. Accuracy is defined as a measure of value. We talked about that. Having this information on my credit report is not of value to me, so therefore it is inaccurate, and I demand it to be deleted from all consumer reporting agencies. So let them know. Let's look at reasonable cause to believe that the information is inaccurate, right? Did we not just go over this in the presentation? So you can literally replay the presentation if you purchase a replay, and just kind of, take my position. The way I'm breaking it down to y'all, break it down to them. So look, I clearly showed you in my previous letter. Remember, this is round 2 example. In my previous letter that you received via certified mail. This is why we sign certified mail, because they can't lie. Oh, I didn't receive it. They have to sign that they received it. That you have reasonable cause to believe that the information is inaccurate by me clearly defining accurate and what it means to be inaccurate and pointing out the laws that you violated. Therefore, the information being inaccurate, right? So this is just an example. And then while we're at it, right? While we're at it, pursuant to 15 U.S.C. 1681A4, like I told y'all can go as simple as just going to the congressional findings. This is where it states Congress makes the findings. There's a need to ensure that consumer reporting agencies exercise their great responsibilities with fairness, right? But the most important part is the respect for the consumer's right to privacy. So once you say that, remember, a lot of these people, they don't know what the law is. They dumb, so you got to break it down to them. So clearly my right to privacy as a consumer has been violated by publicly reporting this information when I never gave your organization permission to report my information. Right, that's a mouthful. Keep that in mind. All right, so, remember, this is a round 2 letter. So now what you could say is, you don't got to say, remember, this is a guide. This is getting out of hand. So if you continue failing to follow the law after I've clearly showed you that you have reasonable cause to believe that the information isn't, in fact, inaccurate, this matter will result in legal actions being taken against your company, and I will be seeking $1,000 for violation of the following. So that would be 15 USC 1681N, civil liability for willful noncompliance, 15 USC 1681O, civil liability for negligent noncompliance. So they're willfully non-complying and they're being negligent in their noncompliance as far as them not removing the late payment that I am demanding that they remove, because I've showed them and proved to them that they have reasonable cause to believe that the information is inaccurate. Therefore, it must be deleted from all consumer reporting agencies. That is what is going on in this whole scenario. And furthermore, you could even copy and paste 1681N. I didn't do that in this example, but it's something that y'all could do just to show them. Remember, I said earlier, any actual damages, any damages could be your mental health, damages could be you getting denied, damages could be anything. And you just point out the fact that they're in violation of $1,000 per violation. Remember, I said in a separate class, we're gonna walk through the $1,000 per violation. I saw somebody ask, how do we get the money from them? We're going to walk through that in a different class, but I want y'all to really, really focus on getting these deletions first. Let's focus on the deletions and then we'll get the money after. All right, so then what I would do to end the letter, it doesn't matter how much time you give them. You can give them 30 days or whatever, but I just put an example. You could put, you have 14 days to respond upon receipt of this letter to delete the reference items and send me a new letter, notify me that the information has been deleted from all consumer reporting agencies, and also mail me a copy of my report, right? So you as a consumer, remember, you're giving them instructions. So when it comes to like debt, when it comes to Fair Debt Collection Practices Act, we're not talking about that today, but just for the sake of my example, you could literally send them a cease and desist and tell them, when it comes to like a collection or something, you could tell them to stop contacting you because you're trapping them in a situation. You tell them to stop contacting you. If they continue contacting you, that is a violation because you have a right to privacy. I've shown you like 18 times you have a right to privacy. So keep that in mind. And then you'll end it with best regards and your name. And a best practice is you want to always have a copy of your ID and a utility bill showing your proof of your address, your current address, right? So you want to also mail that with your demand, because a lot of times these consumer reporting agencies do things that are called stalling tactics. So if you don't send your form of ID, they might be like, oh, it's not you. We're still looking into your case. We need proof of, whatever. So because they're going to do that a lot of times, just send them your identification right away. Want to give them no excuses, right, to move forward with the process, because you got to understand that credit takes time. So if we can minimize the amount of work we got to do, the better we'll be within our situation. So that's an example of how I would walk through a demand. This is how, my clients have gotten negative items deleted. And this is how you're going to get your negative items deleted. And one thing I'll say that's worth mentioning too, because I was on a consultation call too with this girl, and she was basically saying how she was tired of, sending letters after letter. Why is it not working? She got a couple of bureaus off, but I said bureaus. When we talk about the language, you know what I mean, Experian, TransUnion, Equifax. So she got a couple of the consumer reporting agencies off, but it was one of them that wouldn't budge. I want y'all to have that mindset. You got to be consistent. Not only do you have to be consistent, you got to be persistent. I had a client, she went like 7 rounds just to get an item deleted. So imagine if she was like, oh, I'm doing 5 rounds, it doesn't work. Or I did 6 rounds and it didn't work. All she needed to do was 1 more round. So when it comes to sending these letters, whether you're sending like an FTC report, one hack I'll say is you want to send the same thing you're sending and then send a new one. So let's say you send an FTC report, 14 days later, I would send a new one, but maybe 10 days later, I'd send the same one just as a reminder, just constantly be in the flow of it. I covered it on the podcast, I don't remember what episode it was, but just binge listen to the podcast and you'll hear what I meant by that as far as the FTC example. Any questions based off of the template letter? Let me know. Any questions based off of the template letter before we move on to the affidavit of truth? Any questions? Any questions? Let me know. Let me know. Let me know. I need a water break. How y'all feeling? I know most of y'all that's in here got the template letters. I know a couple people that weren't able to make it tonight also got the template letters. But let me know if y'all have any questions as far as these laws. Thank you for the information, King. This is helpful. No problem. Thank you for pulling up. Thank you for investing in yourself. Thank y'all for investing in yourselves. Okay, we're gonna move forward to the affidavit of truth example. Hopefully y'all not tired. All right, so affidavit of truth example, very simple. There are 6 parts to an affidavit of truth. That's all I want y'all to realize. So we're gonna cover the affidavit of truth, then we're gonna cover the process. And then, we're gonna cover a little bit extra resources. And then if y'all got any last minute questions, we'll cover that and then we'll be out of here. So you can take a screenshot, you could do whatever you gotta do with it. But affidavit of truth, number 1, has a title. Number 2, statement of identity. Number 3, statement of truth. Number 4, statement of fact. Number 5, affiant facts. And then number 6 is a notary seal. So basically, with the title, I like to be very, very simple. So you could literally put affidavit of truth, right? Don't got to be nothing serious. So statement of identity. Statement of identity is who you are, right? Do you have an affidavit of truth example to send us? So not technically, but I could put something in the CAT Credit University, like a template letter. That's a good question. I don't even know why I didn't have an example already in there. But I'll type a little bit here, and then y'all can use that. But I'll have a more polished example in the Credit University. That's a great question. Thank you for asking that. So statement of identity is basically who you are. So the way that I put it, I have my example here. I usually just say notice to all. I am, and then you could just say, a natural person. I am the natural person. Your original creditor when it comes to Truth in Lending Act. That's a whole different conversation. Consumer. And then you could say, given the name, surname. Let's say John Doe or something, right? So it's really just who you are. And then I would end it with, and I have been appointed and accept being the executor, both public and private, for all matters proceeding, right? So you're basically establishing who you are. Statement of identity. That's what number 2 is. So number 3 is statement of truth. So statement of truth is basically because affidavit of truth, you can't lie in it because you're under penalty of perjury. It means that it's illegal for you to lie on affidavit of truth. So with statement of truth, you're basically, you're saying that you're not going to lie. So this is how I'd write my example. Whereas I, of age of majority, give this notice to all. I make a solemn oath to the Most High under the penalty of perjury that the following are factual, or something like that, right? And it's statement of fact. So statement of truth, you're basically just saying that I'm not gonna lie in this affidavit of truth. These violations are the truth, etc., right? Because it's illegal to lie in an affidavit of truth. It's illegal to lie in an affidavit of truth. It's illegal to lie in an affidavit of truth. So statement of fact, you're just literally stating a fact. You're literally stating a fact. So when we're dealing with the Fair Credit Reporting Act, we can state a fact as far as what the Fair Credit Reporting Act is intended, right? So you could literally go to quote 15 USC 1681A4. You would say like fact, the Fair Credit Reporting Act or the FCRA states that the banking system is dependent upon fair and accurate credit reporting. That's a statement of fact. It's a fact, right? That's what the Fair Credit Reporting Act states. We went over that in the congressional findings. So you could state however many facts you want. It's up to you, right? So you're just making a statement of fact. And then affiant facts. Affiant facts, and affiant is somebody that's writing an affidavit of truth. So you are the affiant. So the affiant facts, now we're getting straight to your facts, right? So when we're saying your facts, we're just talking about, let's talk about an example I did. So with the auto loan inquiries that I did, I used I included affidavit of truth with, my FTC and everything to remove those inquiries. I basically said, so this is how I do it. I put fact, affiant, which is me or you, is aware and has proof in the attachment labeled as Exhibit A that Bank of America, for example, is in violation of, and then you put whatever they violate, 15 USC 1681 A to A I. Right, which talks about the transactions or experiences, because it's not supposed to be on your report. And experience is that inquiry I got, right? Or that inquiry you got. So that's an example, and then you just list all your exhibits. So exhibit is basically proof of how you were violated, right? Because remember, you can't lie on affidavit of truth. It's a fact. So on a separate sheet of paper, I would write literally Exhibit A. I would circle it, Exhibit A, violation of 15 USC 1681 A2AI. So this is what I did when I was removing my inquiries. But I believe I used 1681B number 2, which is written instruction of the consumer, because I didn't give them written permission to furnish those inquiries on my report, right? So you just list out all the violations that occurred. You don't have to send an affidavit of truth, but it's definitely gonna help. And then number 6, the final part is a notary seal. So every affidavit of truth has a notary, right? So the notary seal, when you get to the notary seal, you could, before you get to the notary seal, you could put thank you. I'm just going off my example. I swear to all the information provided, I do so under the penalty of perjury, that the information I so affirm to be true, correct, accurate, to the best of my ability and knowledge, so be it, right? So then you'll include like a signature. Let me scroll down. Like, why is it so low? Signature, and then, you sign it, sworn to, affirmed by, and subscribed before me on the, you insert the date. So today's what? The 30th? Day of what? January? That's when you would insert that. Shout out to Aquarius season. You feel me? Year 2022, right? We're in 2022. So you would put the date and, the month, and then you'll put the notary name, which is the person that's, the notary, and then notary signature, and then he or she will sign it, the notary, and then you'll have the actual notary seal. I have an example here. I don't know if y'all can see it. It might be. So that's a notary seal right there, right? So that's basically affidavit of truth. So you'll be publishing affidavit of truths as like extra ammo, just to point out, how they violated you. So keep that in mind. when you see an affidavit of truth, this is the real sauce on it. So with the affidavit of truth, when you go to your affiant facts right here, right? If they don't reply line by line, disputing, saying, oh, this is false, this is false, this is false, then your affidavit of truth is considered correct, right? It's considered correct because they didn't deny it. They're supposed to deny it line by line. Let me give y'all the spoiler alert. They never, you know, line by line say like, oh, this isn't correct, this isn't correct. In my experience from doing it, in my experience from hearing, you know, clients do it, in my experience from hearing anybody do it, I never heard about the company going through an affidavit of truth and denying line by line. Remember, this is law. Affidavit of truth, they're supposed to deny stuff line by line. So what you're doing by submitting an affidavit of truth, submitting multiple of them, you're basically creating a paper trail. A paper trail, because in case it goes to court, if they sue you, you sue them, you have all your paperwork in order. And part of that is making copies of everything. You want to make copies of everything so that you have that paper trail and so that your argument is very, very powerful. And then, you know, it's less likely that you're going to lose what's going on. You can go to court as a pro se litigant, which means representing yourself, and then you'll be good to go because you understand the Fair Credit Reporting Act, you understand the affidavit of truth, you understand all these laws because you're going to watch a replay. You have notes from tonight. And yeah, so any questions on affidavit of truth before we go into the process? And then we will, if y'all got any questions, then we'll close it out. Oh no, I got some resources I want to show y'all too before. Any questions on affidavit of truth? I'm gonna need the template. All right, I got you. I got y'all. I'm gonna have something in the university. I'll have my assistant edit the website once I, you know, get like an official one. But I mean, you can literally Google it, Google an example. But if y'all want to use, you know, something that I would use, then I'll have that in the university for y'all. How y'all feeling? Y'all good? Y'all awake? Y'all sleep? I know y'all East Coast people. Oh, it's only 8:53 for y'all out there though. So y'all shouldn't even be sleeping like that. All right, so we're gonna talk about what's it called? The process, right? So one thing I want y'all to know about the process. This is a process, not the process. My boy say you tired, low key. Okay. So I know we got people tired. I know we got some people on the West Coast. So y'all are 5:53 with me too. But some people are East Coast time. So this is a process, not the process. So everything I'm showing y'all tonight, besides the law is the law. That's what it is. But besides the law, everything else is like negotiable, right? So you don't got to follow how I did my affidavit of truth. Besides having the 6 parts, you don't got to follow this process. You don't got to follow the exact template letter. Everything is a guide. The main thing I want y'all to understand is the language of the law. A lot of people, they want to start running before they walk. You got to walk first. Walking is understanding the language of the law. Walking is getting the deletions and mastering the deletions first before we start running to try and, you know, get excited about money, getting excited about, you know, getting a car, 0 money down, all that, right? Getting a car, trapping them in Truth in Lending Act violations. So really understand mastering deletions first. I want y'all to be very, very confident in mastering deletions. I want y'all to be very, very confident in quoting these laws. And then we could start running. But yeah, let's continue. So number 1, this is a process. Understand the language of the law and how you're violated as a federally protected consumer. Under Title 15, Chapter 41, which includes Truth in Lending Act, Fair Credit Reporting Act, Fair Debt Collection Practices Act, you are a federally protected consumer within this United States corporation pursuant to what? 28 U.S.C. 3002. 28 U.S.C. 3002, if you write that down, you scroll down to number 15, it defines the United States as a corporation. That means the United States is about business. What is business? Doing commerce. Business is money. Business is commerce. Commerce is you applying for, you know, Chase, you applying for Bank of America, you applying for Key Bank, you applying for all these local credit unions, all of that. So the world runs on credit. The world runs on credit reporting. So even if you're not passionate about credit, even if you're not passionate about the laws, you're doing yourself a disservice if you don't understand how it works, right? That's why I want y'all to really understand. So once you understand it, and you understand how you are violated, we can go to step 2. So if it's applicable, send a debt validation letter, right? So an example is like collections. If they trying to say, oh, this is an attempt to collect debt, et cetera, send them a debt validation letter because they have to prove that it is your debt. We're not going to get into debt, but debt is an obligation or alleged obligation, right? Do what you will with that information. So 2.5, draft up a cease and desist notice if applicable, right? So an example is, if you have a collection or something, draft up a cease and desist, be like, stop contacting me. It's a violation of 15 USC 1692C when it comes to collecting a debt. That's a communication section because a debt collector is not supposed to communicate with you as far as the connection of a debt. So you can draft up a cease and desist letter, and that could be very, very powerful within your situation because you're coming up with a paper trail. Number 3, identify the law or laws you wish to use in your demand for your deletion. Remember, we're going after deletion first. Deletion first before we go to the money. Let's focus on one thing at a time. Deletion first, right? So an example is 15 USC 1681B number 2, written accordance of the consumer, right? You didn't give them written instruction to publish that information. Identify the law you wish to use in your demand for your deletion. Number 1, we want to get that deletion. We want to get that information deleted from all consumer reporting agencies, and then we will be happy to move on to the next step. Do you have a cease and desist template? No, but you can Google that too, or I can put something in university as well. Dang, y'all want all the letters. You know what I'm saying? But no, I got y'all. All right, so once you do all that, number 3, now we go on to number 4. Now you're going to draft up your round 1 letter, like the template we discussed in the class. Copy and pasting the law. Walk them through the law. Walk them through how they violated you. Walk them through how the information is inaccurate because you understand the law. You understand the language, right? Even if you understood everything I said today, it's good to continue practicing, right? Because you could, let's say you're a master of the law. Let's say you consider yourself a master of the law. If you're good at basketball, if you're good at football, you obviously got to go to practice, right? This is good for me too, because I got to be on my P's and Q's understanding what the law is. So I got to break it down to y'all. So really understand. It's good to consistently, be looking at the law, and drafting up these letters are really, really going to help y'all continuing to be good with the law. All right, so number 5, paper trail. We want to make copies of everything. Then we're going to mail out certified mail and get a green return receipt. Get a green return receipt. We're going to mail out copies, mail out certified mail, and get a green return receipt. Why do we want to mail out and get a green return receipt? We want to get the green return receipt because that's proof that they received our letter, whether it is a furnisher, whether it is Experian, TransUnion, or Equifax, right? So really understand that. Once you make the copies and mail out, now what we're going to do is we're going to file a CFPB complaint. What did I say earlier? There's no such thing as a bureau besides the CFPB. The CFPB is a Consumer Financial Protection Bureau. And you got to talk to them like you're talking to these CRAs, Consumer Reporting Agencies. You got to break down the law to them like they're babies, right? So same thing with your CFPB complaint. The CFPB complaint, you got to look at it as the CFPB is like your employee. But to be honest, as times get more recent, now we're in 2022 versus 2021, when things have been working maybe a little bit better, they're catching on to different things and they're coming up with different rules. There's different regulations and things like that. So the main thing I want y'all to look at when it comes to the CFPB is you want to look at it as a paper trail for the work that you've submitted, right? Because you're building up a case. You want to look at it from the moment you've been violated to you understanding it, from the moment you send your very first demand for them to delete the information from your report. You're building up a case, and we're going to look at some past CFPB cases just to give y'all a little bit more confidence about how, some people are getting paid based off of these inaccuracies. So once you file a CFPB complaint, you can also file a BBB complaint, a Better Business Bureau complaint. Again, paper trail. You could also file an FTC report. FTC report is the identity theft report, right? So identity theft meaning no consent. So you got them inquiries, go file the FTC report. go listen to the CAP podcast. I already walked y'all step by step on how to do all that. State Attorney General complaint. So every state, they got a state attorney. So if you just Google State Attorney General complaint, you can file a complaint. You have that under your belt as well. So Attorney General complaint, and then OCC complaint. So OCC is basically the regulators of banks, and we're going to walk through a resource as well, just to kind of help y'all as far as that. So you just want to establish a paper trail with everything. Certain things work for different people. Some people, they'll file a Better Business Bureau, and then things will get handled. Some people, Better Business Bureau won't do nothing. So it's like, it really just depends on your situation. So once you do all that, now we're going to round 2. So round 2, what are we doing? We're going to draft up a round 2 letter. We literally looked at an example of round 2 letter here in the class. So, do what you will with that information. Scroll back if you're watching the replay right now. And then you could draft up an affidavit of truth. So this process, I'm telling you right now, you don't necessarily submit an affidavit of truth in your first round, even though you can. Remember, I said this is a process, not the process. It's not the only process. It's multiple ways to skin a cat. You don't even got to use consumer law to get deletions, just that y'all are interested in, learning consumer law because consumer law is powerful. So draft up the affidavit of truth, same example we showed earlier. Again, make copies, mail out certified mail, get a green return receipt. And then same thing, file CFPB complaint, BBB, FTC, Attorney General complaint, OCC complaint, just have a paper trail of everything. Every time you file these complaints, you're going to get like an email. Sometimes you're able to print out a copy of what you filed. Make copies of all of that. All those are exhibits. All those are attempts that you made in order to get the negative information removed, right? So just really remember, all of this is a paper trail. And remember, most importantly, a lot of this stuff takes time. So be patient with the process. And then repeat until you get your desired result. Based off of this class, remember, your desired result initially should be just to get the deletion. We can go after the remedy, meaning the money for the damages later. But initially, you want to focus on the deletions. I want y'all to get comfortable with the deletions, right? You got to get comfortable with the free throws before you start, starting to shoot Hail Marys like Steph Curry. You know what I'm saying? So really just keep that in mind. And that is the process, or a process, I mean. That's not the process. Do y'all have any questions? We're going to walk through just some final resources. And then, yeah, I want y'all to ask any questions if you do have any. It might be a lot of information. Maybe y'all just got to actually execute it. But yeah, if y'all have any questions, let me know. Can you walk through submitting an FTC complaint? Okay, I know that you're new to following me, but I literally put out a podcast episode where I did that. So just for the sake of time, everybody's time, I'm not going to do that because it's in the podcast episode. So yeah, you could definitely go back and listen to the podcast, and I have an example there of where I walked through FTC report. I think y'all might be tired. Maybe y'all not tired. I don't know, but yeah, we're gonna go through the final resources. So yeah, okay, I got a resource here that I want to go through. It's gonna be helpwithmybank.gov. So basically, helpwithmybank.gov. This is the OCC. Like I told y'all, the OCC. Oh, that my light tripping. The OCC is basically the regulator of banks, right? They regulate banks. So they regulate Chase, all them peoples. So if you don't know who regulates your bank, because maybe let's say you're not getting your desired result, I want y'all to go to helpwithmybank.gov. Helpwithmybank.gov. I want y'all to go over there so you can file a complaint. Remember, you as a consumer, you can file a complaint with anybody you want to file a complaint with, right? So this is what they say here. Before you file, try to resolve your issue directly with your bank first. But this is assuming that we already tried to, right? So now what we're going to do is we're going to file a complaint. So you can go here, file a complaint. And what I wanted to show y'all is really number 2. So number 2 says, check to make sure we regulate your bank. So if you're not sure if the OCC regulates your bank, you can go to who regulates my bank, right? So then you're going to come here to search financial institutions. So now we come to the FFIEC website, and this is just a helpful resource just to, give y'all more information on who's regulating your bank. So let's say I want to figure out Wells Fargo. right? So Wells Fargo, I want to look at National Association because I want to just look at globally who regulates, unless they specifically have who I'm looking at. So I see right here, Office of the Comptroller of the Currency, that's OCC. So I've confirmed to myself that Wells Fargo is regulated by the OCC. But if I look down here, Wells Fargo International Banking, they're regulated by the Federal Reserve, right? So the reason why I'm showing y'all this is because if I'm going at Wells Fargo International Banking Corporation, and I think it's the OCC that's regulating them, so I submit an OCC complaint, I'm already going to the wrong target. So you got to really use this as a resource and really understand who regulates your bank. So add that to your toolbar. I want y'all to add that over there. Okay, yeah, last resource, and then we go. If you guys have any questions, if y'all not sleeping, and then we gonna close it out. So sometimes this is what I do for fun. I just look at CFPB past complaints. So you can look at CFPB past complaints. You come to the database right here, and you see right here, it shows 1 million matches out of over 2 million complaints, right? So this is throughout the world. So you can just Google CFPB past complaints, and this can help you with confidence, right? I know y'all like the money, so we're gonna look at some cases where there was money, right? So we'll scroll down here. So you want to look at the section where it says company response to consumer. Company response to consumer. Who's a consumer? You and I, right? So what we want to look at is we want to look at close with monetary relief. What does that mean? Close with monetary relief means that the CFPB issue was closed where the consumer got paid, right? When we talk about getting paid, we can talk about damages as far as $1,000 per inquiry. We're going to cover that whole process in a different class, but just as an example. But y'all see right here, close with explanation, that's a majority of what happens. You got over 1 million results right here, globally. So let's look at close with monetary relief, because, we're looking at the money. But we got to filter even more because, look, it shows different sections of what happened as far as what was closed with monetary compensation. So credit card is most popular, 15,000. What we're interested in is the least popular, which is credit reporting, credit repair, etc. So we're going to go to filter it again, right? So we look at the issue over here. We could expand this. Hold on. Okay, I'm in the wrong session right here. So product is credit reporting, credit repair services, or other personal consumer reports. Because remember, we're Fair Credit Reporting Act right now. So remember, look at the timeline. From January 30th of 2019, literally 3 years ago, up until 3 years today, which is January, at the time of the recording, which is January 30th, 2022. So what we'll do, go to list. This is what you want to click right here. Because once you come to the website, you're automatically on the map. So you can look at map, you can look at trends, but you want to look at the list because that's going to give us the data. So we click on list. So then we can actually literally look at it. Look, date received. What is this? 126 was what? 4 days ago, right? You can see the consumer state. They live in California. Shout out to my West Coast people, California. So basically what happened, the issue was with this company, Grant Mercantile Agency. That sounds like a person defined in the Fair Credit Reporting Act, right? So Grant Mercantile Agency, they sound like a furnisher of information. Basically, the situation was closed with monetary relief. But what was the issue? Credit reporting. Incorrect information on your report. Information belongs to someone else. So what happened? This person 4 days ago, they got paid for information that belonged to someone else being reported on their report. When it goes back to accuracy, that's both inaccurate in terms of not being correct, but that's inaccurate and not being valuable. Because why is somebody else's information on my report? What if that person doesn't have good information? You know what I'm saying? So just look, 4 days ago, going through these sections can give y'all confidence as far as getting paid after we get the deletions. Let's look at another one. So 120, January 20th, what is that, 10 days ago? The consumer state was Texas. So it's not only in California. So close with monetary relief, what does that mean? Damages were sustained, they got paid. Alliance Data Card Services. That sounds like a furnisher of information. So what was it? Credit reporting again, right? Problem with the credit reporting company's investigation into an existing problem. Their investigation did not fix an error on your report. So because the error wasn't fixed, they got paid. What does the error not being fixed sound like? Sounds like I'm submitting all of these letters and I didn't get the deletion, right? So these are damages. Maybe you lost sleep because you didn't get the negative information deleted. So keep that in mind. Let's look again. Let's look at maybe a couple more examples. Let me even scroll down a little bit more. Let's just randomly stop right here. So January 6th, 2022, right? What state? Georgia. Revenue Enterprises LLC. So that sounds like a company or something. That could be a person. Close with monetary relief, credit reporting issue, account information incorrect. Incorrect information on somebody's report. Account information incorrect, right? So you could literally get paid for information being incorrect. If something's reporting and is incorrect on the report, it would be a disservice to you not to submit a CFPB complaint. If they're not complying with it, that's willful non-compliance. That person probably understood. They have the law at their disposal, 15 USC 1681N. Maybe they did willful non-compliance, or maybe they did 15 USC 1681O, negligent non-compliance, right? So it's really just up to you. Let's look at one more example. All right, so same thing, right? So Citibank was the issue, close with monetary relief. Their investigation did not fix an error on the person's report. So the whole point of me showing you all this is that it allows you to know people are getting paid for this information. And I want y'all to know that the money is there. You will get paid, but first master the deletions. First master the deletions. I want y'all to master the deletions, right? So last thing I just really want y'all to understand is, I said it earlier, but with the CFPB, you got to understand that you're talking to them like they're babies. Let me stop sharing my screen. So I'm pretty much on that. So with the CFPB, you're talking to them like they're babies. Because you're talking to them like they're babies, you've got to understand that they don't necessarily understand the law. They don't understand all the time what's going on. These are employees that probably get like, $10, $9 an hour or something. They don't get paid like that, right? So they just trying to go home like anybody else. So really, really break down the law. I hope this class gave y'all value. If y'all awake, let me know how y'all feeling below. Let me know if y'all got any questions. Oh, one thing I wanted to say too. I think I said it earlier too, but if you look up 15 USC 1666B, it talks about the timing of payments that could be effective in terms of removing late payments. And then 15 USC 1666, scroll down to B again, correction of billing error. So those are a couple more weapons to add to your tool belt when it comes to deletions. This was a lot of information. If you purchase the recording, then definitely, definitely understand that it's just going to be consistency and persistence to help y'all move forward. Any questions? I'm going to let it be like a couple minutes if I don't hear any questions. I mean, if I don't read any questions, then we're going to get out of here. Hopefully this gave y'all value. Hopefully y'all not sleeping right now, But if y'all sleeping, then, it is what it is. It is what it is. Any questions? How y'all feeling? Thank you. This was a lot of great information. I just need to implement. Okay, appreciate you. Appreciate you tapping in. I know you're in the East Coast, so, I appreciate you staying up. It's only 9 o'clock though, but, anybody could be tired at this time. Any questions? Any questions? Did I light y'all up with information? Is that it? Did I light y'all up with information? Fire emoji. I appreciate that. I appreciate that. I appreciate you. Okay, no more questions, I don't think. All right, yeah, man. With that being said, I think that's all we have. But yeah, with that being said, man, y'all have a blessed one. I hope you enjoyed the FCRA. I hope you got some practical stuff you could take to go ahead and get to the next level. Now we're going to talk about the FDCPA, which is the Fair Debt Collection Practices Act, and this is 15 USC 1692. So this is going to be when you're receiving those texts, emails, phone calls, and this is where you go and you're sending your debt validation. So without further ado, we're going to get straight into it. If you've gotten value so far, you can click the link below and you can enroll in CAT Credit University to get our template letters and just get in a community of like-minded individuals that are also looking to get to the next level. Enjoy the video. All right, we're gonna get straight to it. So, my name is Michael Benjamin. I'm the CEO of Consumer Ammunition Tactics, or CATS. I think everyone in here, knows me. You probably talked to me. You probably talked to my assistant. You probably talked to someone in our business. So tonight, we're going to be breaking down the Fair Debt Collection Practices Act, which is the FDCPA, or 15 USC 1692. All I ask is that y'all have an open mind and take action on the information that we're going to talk about tonight. It's going to be a lot of information. We're going to go deeper than just Title 15. I'm going to be diving into things I only talk about in consultations, things that I don't talk about on a podcast because, you never know who's listening. And I don't want the information I'm going to be putting out into the wrong hands. So yeah, with that being said, let's get straight to it. All right, so housekeeping rules. I just need y'all to take action. Taking action can be simply taking action on information I give you. If you guys want to post on your story and tag me, that's taking action as well. Let people know, what's going on. You learn this information, you're about to get to the next level. So just take action. Don't overthink things. Take action. That's the main thing. All right, so the agenda. So we're breaking down the FDCPA, like I said. So first of all, it's going to be FDCPA literacy. So Fair Debt Collection Practices Act literacy, right? So the FDCPA is 15 USC 1692. You can take a screenshot of this if you want, so that while we're going along, you could follow along. But 15 USC 1692, it's the congressional findings and declaration of purpose. Words are very, very important. If you go to the Fair Credit Reporting Act, or if you got the replay that I did, it's congressional findings and statement of purpose. The Truth in Lending Act, I'm gonna do a class on that maybe next month, maybe the following month. Congressional findings and declaration of purpose. I wouldn't focus too much as far as declaration versus a statement, but I just say that to say the congressional findings is where Congress found something was going on that was wrong, and it's why they came up with the law. 15 USC 1692A, definition section. When you're reading the law, the big three or just any law, there's always going to be a definition section. Definitions, just defining, the different terms that's going to be used in the following sections. The FDCPA in particular has 8 definitions. I don't know everybody's familiarity with the FDCPA, but the FDCPA has 8 definitions. So not too many. We're going to focus on them. Then we're going to go into 15 USC 1692B. 1692B is an acquisition of location information. So we're going to dive into that. We're going to go over some violations over there. And those of y'all that know, pursuant to 15 USC 1692K, civil liability section, each violation is at least $1,000. So we're going to talk about it and, help y'all as far as getting paid and things like that. Then we're going to go into 15 USC 1692C, the communication section, communication in connection with debt collection. The communication section is one of my favorite sections because literally if a debt collector communicates with you, that's a violation. You know what I'm saying? So it's going to be a lot of violations. Then we're going to go into 15 USC 1692D, harassment or abuse section. Harassment or abuse, an example is a debt collector simply saying that this is an attempt to collect the debt. You as a consumer, you decide what is harassment or abuse to you. So we're going to get into that. Then 1692E, we're going to talk about false or misleading representations. Some of y'all may have seen when I posted about speeding ticket, as far as a police officer pulling you over. I'm going to go a little bit deeper into that when we get towards the end of the class, and you'll kind of know where to start when it comes to disputing a speeding ticket, as far as, getting paid and things like that. All right, after that. So 15 USC 1692F, unfair practices. Unfair practices, we're going to get into that. And what you're going to see is that some of these laws might seem redundant, but the thing about them seeming redundant is it works in your favor, because if you get a violation that's in 1692F, but it's also in 1692C, you didn't just get a $1,000 violation, you got $2,000 violation, right? And then we're going to go over an example of the invoice. I'm going to show y'all how to structure that, how you should structure it. Then we're going to go into 15 USC 1692G, validation of debts, right? We're going to get into the definition of debt and just everything that needs to be done to validate a debt. But spoiler alert, these debt collectors, they can't validate a debt because you, the consumer, have the power to actually validate that debt. Then we're going to go into multiple debts. So that's 1692H. I'm gonna show y'all what y'all can do to send out a notice and, you know, get additional payment. Then we're gonna go into 1692I. One, again, it's redundant, but it's gonna talk about legal actions by debt collectors. So I'm gonna give y'all a law that shows you and proves to you by law, debt collectors are not allowed to sue you. Corporations cannot sue you. So I'm gonna give y'all that law. I haven't mentioned it on a podcast or anything. It goes beyond Title 15. So, you know, just stay along, hang in there. We're gonna get through it. If you leave early, you're not gonna get it. And when I do, when we chop up the recording, for those of y'all that got the recording as well, we might chop out some of the information. So you want to stay through the entire class if you can. 15 USC 1692J, furnishing certain deceptive forms. So when we talk about, for example, your auto loan contract, just the fact of when you see under the name creditor and it says somebody else that's not you, that's technically a deceptive form because you are the original creditor. We're not going to get too deep into that in this class. That's more of a Truth in Lending Act thing, but, you know, just pay attention. We'll get into it. And then we're going to wrap up the literacy with 15 USC 1692K. This is a civil liability section. This is where you're going to go as far as, you know, getting your remedy, getting your money, things like that. So yeah, just keep that in mind. All right. So after we go through the literacy aspect, that's just part one. After we go through the literacy aspect, we're going to go over the administrative process. I'm going to talk about a process, not the process. There's multiple ways to, you know, skin a cat. So just understand that when we're going through it. Then we're going to go over an affidavit example. Affidavit example, what I think you should do as far as moving forward, as far as getting your remedy, whether that is a deletion, whether that is getting paid, things like that. We're going to go over an invoice example. So the way that I believe you should structure it, the way that I was taught to structure it, because I used to structure it differently, but I was taught by my mentor a different way to actually structure it. So I think it'll be of benefit to y'all. Then I'm going to give y'all some information, extra information on deleting charge-offs. If you've listened to my CAP podcast episode where I talked about deleting charge-offs, I talked about deleting charge-offs, but I didn't talk about what I'm going to talk about tonight, right? So it's just an extra measure you could take as far as deleting charge-offs. So we're going to get into that real quick. Then we're going to talk about litigation with the debt collectors. So suing debt collectors, because we don't have time to be just sending them notices all day and not even getting what we desire, right? So then we're going to talk about that. Then we're going to talk about miscellaneous bonus info. This is where it's going to go deeper than just Title 15. So a lot of the stuff in the miscellaneous section we're going to talk about, I've never covered it on the podcast. If you have ever heard anything I've said in the miscellaneous section, you've probably booked a consultation. And those of y'all that know, my consultations for 30 minutes are $350, right? So I only trust certain people with the information. You feel me? And then we're going to get to final remarks and then, you know, any questions y'all got, and then we'll get out of here. All right, so number one, mindset. I need y'all to study, right? Study these laws, but do not overthink. Overthinking leads to you not taking action. And I would hate for y'all not to take action because you're trying to just figure out the difference between one phrase and one word, right? So don't overthink yourself out of taking action. Please do not overthink yourself out of taking action. Number two, embrace the spirit of execution because it takes time. What do I mean by that? I mean, embrace the spirit of taking action because the whole process takes time. You know, when you send out a letter as far as like the credit reports, consumer reporting agencies, it's like 30 days for them to, you know, reply to you and things like that. We're going to see in the affidavit that I have, I specify 14 days because I like my process to be quick, but I don't want y'all to be in a habit of, okay, I sent this out 30 days. They got to reply. I sent this notice out 30 days. I got to reply. I sent this out 30 days. I got to reply. We're going to go over the administrative process. You could do it like that, but we're going to talk about a way you can combine everything just in one notice and then just get straight to litigation if you need to go that route. So just execute and do not overthink. I'm going to walk through the most important parts I think you should have in FDCPA. If y'all got questions, you can ask, but if it's beyond the scope of what I'm covering, I might, you know, just tell you not to focus too much on it because you want to look at it as use only what you need to use to get your desired result. You don't need to use everything in FDCPA to get your result because FDCPA goes from 1692A all the way to P. We're only covering 1692A all the way to K, right? That's all we need to get our desired result. So don't just have so much information and just be like, oh, I can say 15 USC, 1692, whatever. Use only what you need to get your desired result. I had a lot of when I first started, studying, I had a lot of just unnecessary dealings with just trying to memorize and know everything. Just get what you need and move forward. Don't overthink. That's my point. Hopefully that mindset helps you guys listening live or, somebody watching the replay. All right, so I'm a big believer in mindset and writing things down. So if y'all attended FCRA class or you watched the replay, this may look familiar. We got the same statement. I'm gonna need you to write this down in your notes. If you're typing, if you're writing, do whatever you gotta do. Put I, insert your name, understand that everything I was taught about credit before may not have been true, and I promise to open my mindset to what I learned today. Sign, and then put your name. I'm gonna give y'all like a minute or something to do that real quick. And then I'm gonna continue. And you guys can put done in the comments once you actually write that. But yeah. All right, yeah, for the sake of time, let's continue forward. Okay, yeah, before we actually get started, any questions for me? Any immediate questions for me? Y'all let me know. I might take like 1 or 2 questions before we get into it. We got a lot of information to cover, but I want to give y'all the space. FDCPA related questions to ask me real quick before we actually get started into interpreting the laws. I'm going to assume it's no questions and get straight to it. Okay, let me know. Can y'all see my screen? The law of Cornell 15 USC 1692. Let me know if y'all can see that. Let me know if y'all can see that. Okay, perfect. See, I got one C. I'm gonna get straight to it. All right, let's get straight to it. So like I said, 15 USC 1692. This is a Cornell website. You can go on the Cornell website to read the laws. Those of y'all that listen to my podcast, I've covered a lot of it. So congressional findings and declaration of purpose. Like I told y'all, this section is where Congress found something wrong that was going on. And that's why they decided to create the law. All right, listen, so abusive practices. So this is A. There is abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Let's stop right there. Before we even continue, you see it shows like a hyperlink to the word debt. It's gonna take you to the definition of debt. So when you're reading these laws, I want y'all to get in the habit of clicking these hyperlinks. Because the definition of debt is in the next section, I'm not gonna click on it right now, but I just want y'all to have that mindset of when I see a hyperlink, I'm gonna click on it and get more information. So just in that first sentence alone, there's a lot. There's abundant evidence. Abundant, what does the word abundant mean? It means a lot, right? So there's a lot of evidence. They didn't say there's a little evidence. They said there's abundant evidence of the use of abusive. Does abusive mean you're treating somebody right? No. Abusive, deceptive. What is deceptive? Deception. You're deceiving somebody. And unfair. 1692F, isn't that unfair as well? We're going to talk about it. Unfair debt collection practices. This is where the Fair Debt Collection Practices Act came from. So y'all got to realize that something bad was going on for Congress to be like, let's put out, the Fair Debt Collection Practices Act. So abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability. Marriages are messing up, to the loss of jobs, people losing their jobs, and to invasions of individual privacy. Those of y'all that know in the Fair Credit Reporting Act, 15 USC 1681A, number 4, it talks about, you have a right to privacy as a consumer. So understand that they're also talking about invasion of your privacy in the Fair Debt Collection Practices Act as well, the FDCPA. So we only looked at one sentence or one section, abusive practices, right? So just really understand that there's a lot that really came into this. Congress didn't just wake up one day and be like, okay, let's just put out the FDCPA. It's because something wrong was going on as far as debt collection. They're not supposed to be collecting these debts from you. Everything is prepaid. We're not going to get too deep into it, but yeah, that's what's going on. So B, inadequacy of laws. So you don't need to pay too much attention, but it just says existing laws and procedures for redressing these injuries are inadequate to protect consumers. So basically what Congress is saying is that the current laws that were in place before they put out the FDCPA were inadequate. What does inadequate mean? Not adequate. What does adequate mean? Enough. If the laws were enough, that still wouldn't be good. For something to not be enough, it must be bad. Y'all following what I'm saying? So really just pay attention to, the different words and languages. All right, so available non-abusive collection methods means other than misrepresentation or other abusive debt collection practices are available for the effective collection of debts. So they're just basically saying that there should be better methods to debt collection. The current methods are not good. People are being abused, people are being harassed and things like that. So that's why they came out with the FDCPA. All right, D, interstate commerce. Abusive debt collection practices are carried on to a substantial extent in interstate commerce. Before we continue, interstate commerce is basically, understanding the fact that the United States is a federal corporation pursuant to 28 USC 3002. You go down to number 15, you're going to see the United States is a corporation. So meaning that the United States, you do business. Everything is business. Everything is commerce. Everything is trade. Everything is, personal property, money, things like that. That's basically what that interstate commerce means. So abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means and instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they nevertheless directly affect interstate commerce. So Congress is just basically tying everything back to interstate commerce as far as debt collection practices. It's very bad, right? All right, so purposes. This is where I would focus the most on if you want to focus the most on. You don't need to pay too much attention. This is just like background history information. So purposes is a purpose of this subchapter to eliminate means get rid of, right? Abusive debt collection practices by debt collectors to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged and to promote consistent state action to protect consumers against debt collection abuses. So they basically want to make sure that debt collectors are doing good practices as they are performing debt collection. Before we continue, any questions on this section? I don't think there will be any questions, but I just want to give y'all the space if y'all have any quick questions. Like I said, don't overthink it. I wouldn't place too much attention on this section, but all right, we're gonna continue. If you guys have any, I guess, deep questions too, save that for the end. If you somehow don't get to ask your question, save it for the end. All right, so we're in the definition section. 15 USC 1692A. Remember, every law has a definition section. So the term bureau means the Bureau of Consumer Financial Protection. So I think everybody in here is familiar with the CFPB, the Consumer Financial Protection Bureau. That is the bureau that Obama created when he was president. And the CFPB is basically where you can submit complaints. They regulate the consumer reporting agencies, meaning Experian, TransUnion, and Equifax. Remember, Experian, TransUnion, and Equifax, they are not government related. They are privately owned companies, right? So the CFPB, or the Consumer Financial Protection Bureau, governs them. So when you're putting in your letters, credit bureaus, you're basically not speaking correct language, to be honest. So this is why you want to put consumer reporting agencies. If you don't understand that language, then you need to go purchase the FCRA replay that I did, the 2-hour one. But yeah, so the term bureau means the Bureau of Consumer Financial Protection. They're basically just talking about the CFPB. That's the only bureau that exists. All right, so number 2, remember there's 8 definitions, eight definitions in the FDCPA. So the term communication means the conveying of information regarding a debt directly or indirectly to any person through any medium, right? They said a lot over there. Communication is conveying information regarding a debt directly or indirectly. Let's stop there. Directly means you the consumer, right? You the consumer, meaning John Doe or whatever. But indirectly is you, an example is you on a letter, right? If they send you a letter, notice that your name is in all caps, all capital letters. That's your corporation. That's you as a corporation. So that's what they mean by indirectly. And remember, the word or means whichever side you're choosing on. So if a debt collector communicates with you, meaning they send you a letter they send a letter to you, they're communicating with you indirectly, right? If they call you, they're communicating with you directly. So just keep that in mind. Directly or indirectly to any person. Remember, any means no restriction. So any person through any medium, no restriction, medium. What are examples of mediums? A medium, like I said, phone call. A medium, like I said, mailing. So any form of communication. This is going to be very, very important when we get to 1692C. So just keep that in mind. All right, the term consumer means any natural person obligated or allegedly obligated to pay any debt. So consumer, This is really where I always tell y'all you got to really understand the language, because the term consumer in the FDCPA is differently defined as it is in the FCRA, the Fair Credit Reporting Act. In the Fair Credit Reporting Act, the term consumer means any individual or an individual. We obviously see here that's different from what it means in the FDCPA. So this is why when you're structuring your letters and your notices and things like that, you gotta understand what the definition you're talking about is. Remember, it's a language. You're not gonna use Spanish when you're trying to communicate in English, right? So just really understand that. So any natural person, so no restriction. You're the natural person, no restriction. Obligated or allegedly obligated. What did we say or means? Or means you choose the side you wanna be on. So it's up to you when it comes to a debt, if you're obligated or if you're allegedly obligated. When we talk about 18 USC 8, it talks about that obligation as well. So you got to really just understand, are you obligated to pay that debt, or are you allegedly obligated to pay that debt? So understanding that is really what's going to allow you to be powerful as far as your notices. And we're going to go over an example of affidavit as well, but I just want y'all to be familiar with that. So the term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or transfer of a debt in default solely for the purpose of facilitating collection of such debt for another. Don't think too deep about it. Whenever you're seeing creditor, when it comes to the FDCPA, remember you're the consumer. A lot of times in the way you structure your letters, the creditor is gonna be, that person you're talking to, that debt collector. But technically, when we're talking about Truth in Lending Act, when we're talking about creditor, you are the original creditor, right? So it depends on what you're talking about as far as interpreting creditor. But I don't want y'all to overthink it. I'll just say, in most cases, when you're using the FDCPA, the creditor is going to refer to them. You're the consumer. All right, so the term debt, let's continue. This is a very, very important definition. The term debt means any obligation or alleged obligation of a consumer, right? You're the consumer, right? To pay money arising out of a transaction. I would just stop there, but I'm going to read the whole thing. In which the money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. So when it comes to debt, the main thing I need y'all to really focus on, you can read the whole definition, but the main thing I need y'all to focus on is any obligation or alleged obligation of a consumer, or means you choose what side you want to be on. Me personally, Michael Benjamin, the consumer, when I see the term debt is an alleged obligation of me, right? There's no law that says you have to pay any debt. Debt is an alleged obligation. To me, it's an alleged obligation. If you say it's an obligation to you, it's an obligation to you. When a debt collector sends you something, they say, oh, you owe the debt. If you don't refute it, if you don't say this is not my debt, it stands as is. Remember, silence is acquiescence, meaning that if you don't reply, what they say stands. It's the same, and it's the same thing when you send them an affidavit. If they don't reply line by line, it's an unrebutted affidavit. They didn't reply adequately, so it stands. So just keep that in mind, and you decide if debt is your obligation or alleged obligation. All right, the term debt collector is a long definition. We're not going to read through the whole thing. I just want to give y'all the important part. So the term debt collector means any person, remember any, no restriction, any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is a collection of any debts, right? And it goes on to say, or who regularly collects or attempts to collect directly or indirectly. Remember, directly calling you, indirectly, capital letters, mailing you a letter, right? Debts owed or due or asserted to be owed or due another. So the main thing I need y'all to really understand is a debt collector. Any person who attempts to collect something from you. So this is why a police officer is considered a debt collector, because any means there's no restriction. Congress is literally letting y'all know, these police officers, they are debt collectors. Are they not attempting to collect a debt from you when they're running your credit card, your social security number, right? So you got to really understand that when it comes to debt collectors, it's any person who uses any instrumentality of interstate commerce. Remember, interstate commerce is just like doing business within the United States. So it goes on to say, let me show y'all how police officers are debt collectors. So A says any officer or employee of a creditor while in the name of the creditor collecting debts for such creditor. Any officer means there's no restriction on the officer. It's police officer, right? Policy officer. It goes deeper than that. police policy officer. There's no coincidence why it's, like that, civil procedure and stuff like that. But we're going to get deeper into that later. If it goes to C too. C says any officer or employee of the United States, right? So just really understand that. So debt collectors are debt collectors, right? There's no restriction on debt collectors. All right, so number 7. The term location information means a consumer's place of abode and his telephone number at such place or his place of employment. So location information is 1692B, which we're going to get into in the next section. But basically, location information is just pretty much saying where you're located, because debt collectors are not supposed to have your location information, because you got to remember, you as a consumer, you have a right to privacy. So they're not supposed to be communicating with you, right? So keep that in mind. It can also be your place of employment. And we're going to talk a little bit about that deeper. All right, and then the term state, I wouldn't focus too much on, is just, state. The term state means any state, territory, or possession of the United States. So, somebody said California, wherever you're at. The District of Columbia, the Commonwealth of Puerto Rico, or any political subdivision of any of the foregoing. This is beyond the scope of the class, but the original Department of Treasury was in Puerto Rico, by the way. But yeah, I just wanted to let y'all know that. But any questions on the definition section? Any questions on the definition section? How are we feeling so far? Are we sleeping? We barely even got started. Don't be sleeping on me. Type in the comments so I know y'all awake. Y'all can hear me. Any questions on the definition section? I think definitions are pretty straightforward, but once we get into the later sections, it's probably going to be, it might be some questions. I don't know. I think I did a pretty good job on the podcast explaining. So some of this might be review, but y'all got any questions? Let me know how y'all feeling, at least down below. I don't see any questions right now, so I'm going to continue to 1692B. 1692B. Okay, feeling great. Okay, cool. Maybe everybody else is asleep. I saw feeling great, so at least one person's feeling great. I don't know where everybody else is, but let's continue. All right, acquisition of location information. This is 1692B. All right, so any debt collector, remember the power of that word any, no restriction. Any debt collector communicating with any person other than the consumer, so not you, for the purpose of acquiring location information about the consumer. So what is that saying? It's basically saying that if a debt collector is trying to get your location from somebody that is not you, what's an example of somebody that's not you? The most obvious example of somebody that is not you is like a family member, friend, whatever. But don't sleep on the fact that somebody that is not you is communicating with you indirectly. So if they send a letter to you, right? It might seem like they're communicating with you, but they're communicating with you indirectly. So that's what Congress is saying. They're communicating with you, but they're not directly communicating with you. So that classifies as any other, person that they're talking about. So yeah, just keep that in mind. You got to read between the lines sometimes. It says when they're doing that about the consumer, they shall. So shall means that they have to do it. They shall, number 1, identify himself or themselves, state that they are confirming or correcting location information concerning the consumer, and only if expressly requested, identify the employer. So basically, it's pretty self-explanatory. They just got to identify themselves, etc. Number 2, this is 1692B, number 2. This is one of my favorites that you guys can use as a violation. Not state that such consumer owes any debt. So it's a violation for them to say that you owe a debt to somebody else. But remember, somebody else could be them mailing you a letter, because that's not directly you, that's indirectly you. Have you ever received a letter that said this is an attempt to collect a debt? It has your name in all caps. So that's a violation. 15 USC 1692B number 2. That's a violation of that. You need to write that down. Write it down as an exhibit on that letter, make a copy of it, and send it out with your paperwork. So number 3 says, not communicate with any such person more than once, unless requested to do so by such person, or unless the debt collector reasonably believes that the earlier response of such person is erroneous or incomplete, and that such person now has correct or complete location information. So the main part I want y'all to focus on is not communicate with any such person more than once. Remember, think about the communication other than you as them sending you a letter. So they're not supposed to communicate with you more than once unless you request them to, and you never request them to. So it looks like 1692B number 3 is a violation as well. We already found $2,000 worth of violations. If we want to go with number 1, we found $3,000 worth of violations. Number 4 says not communicate by postcard. So a while ago, debt collectors used to communicate by postcard, but they don't as much anymore. But yeah, so you could skip that section unless you get communicated with by postcard. So this one, number 5, everybody has this violation. Not use any language or symbol on any envelope or in the contents of any communication affected by the mails or telegram that indicates that the debt collector is in the debt collection business or that the communication relates to the collection of a debt. So basically, 15 USC 1692B number 5 is saying that if they use any language on a letter, what is any language on a letter? Literally typing anything, that's a violation. So you already got, you know, are we at $4,000, $5,000 worth of violations yet? If they use a symbol is their logo. If you see a Chase logo on something, circle that. That's an exhibit. That's a violation of 15 USC 1692B number 5. So that's like what, $6,000? We're only in 1692B. We haven't even gone through all the sections. So you got to really understand that they are really committing a lot of violations. You want to really write them down, make copies. And at the end of the day, identifying the violations aren't too hard. It's just about structuring your argument and going to get your desired result in your remedy. But we're going to dive into that. All right, number 6. So it basically says, after the debt collector knows the consumer is represented by an attorney with regard to the subject debt and has knowledge of or can readily ascertain such attorney's name and address, not communicate with any person other than that attorney unless the attorney fails to respond within a reasonable period of time to communication from the debt collector. So 15 USC 1692B number 6 is just basically saying if you have an attorney, they're not supposed to communicate with you. To be honest, we're going to dive deeper later and we're going to talk about you representing yourself, which is a pro se litigant. So I wouldn't focus too much on that violation, but if you have an attorney, then, you know, if they communicate with you, that's an extra $1,000. Any questions? I said any. Any questions on 1692B? Let me know. Are we gonna move forward? If y'all have questions later on, just let me know. So we're going to one of my favorite sections, 1692C. Communication and connection with debt collection. So A says communication with the consumer generally. So communication with you generally. Sometimes it makes it easier to read these laws when you just substitute things with phrases. So you know you're the consumer. So you can say, if your name is John, you can say communication with me or John generally. So without the prior consent, what does consent mean? You're allowing them. Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, a debt collector may not communicate with the consumer in connection with the collection of any debt. Just that section alone. We don't even got to go to, you know, number 1, 2, and all that. You can quote 15 USC 1692CA, communication with the consumer generally. They're not supposed to communicate with you. That's already a violation if they communicate with you. So that's $1,000 right there. All right, number 1, what does it say? At any unusual time or place, or a time or place known or which should be known to be inconvenient to the consumer. In the absence of knowledge of circumstances to the contrary, a debt collector shall assume that convenient time for communicating with the consumer is after 8 o'clock and before 9 o'clock, local time at the consumer's location. Let's break down that second sentence first before we get into the sauce of the first sentence. So it basically says a debt collector shall assume. Does an assumption mean it's correct? Just because a debt collector makes an assumption and then they call you, it doesn't mean they didn't violate you. What if they call you at a time that's inconvenient to you? That's a violation, 15 USC 1692 CA1. So the first sentence, it says at any unusual time or place, which should be known to be inconvenient to the consumer. So this is a sauce right here. What if, okay, let's say you're working your job, right? But what if you're also a business owner? As a business owner, let's say you work 24/7. So if a debt collector calls you, isn't that already a time that's inconvenient to you? I can't tell you what's inconvenient to you, for you, but I can tell you what's inconvenient for me. Me as a business owner, I'm on the go 24/7. So if a debt collector calls me at all, that's inconvenient to me. That's already 15 USC 1692 CA1. That's a violation. That's $1,000. I'm gonna need that, right? So you got to really understand what's inconvenient to you. If you're a business owner, 24/7, you work. If you're at work and they call you, obviously that's a violation. The easiest way, obviously, is you working as a business owner 24/7. You don't even technically got to be a business owner. Maybe you're learning about business. You're still working, so that communication is a violation. Number two, if the debt collector knows the consumer is represented by an attorney with respect to such a debt and has knowledge of such attorneys, etc., it's basically saying right there, which was in the previous section, if you have an attorney, they're not supposed to communicate with you. And earlier in the beginning, I was saying how some of these laws you're going to see are redundant, and it works in your favor, the fact that it is redundant. So in the previous section, 1692B, where we had the attorney law, that was a $1,000 violation. We can come back to 1692C, same violation, $2,000. We just double up, right? So just really understand that when you see something that's like repetitive or redundant, it's going to work in your favor. All right, so number three, at the consumer's place of employment, if the debt collector knows or has reason to know that the consumer's employer prohibits a consumer from receiving such communication. What did I say about you as a business owner? I said, if you're a business owner, right, your place of employment can be literally anywhere. If I'm at the store or something and I'm a business owner, 24/7, I'm working. I might be buying some stuff for my business. You communicate with me, you call me, that's a violation of 15 USC 1692 CA3. So really just understand how it can work in your favor, right? Congress made these laws for you. It's up to you to utilize them the correct way. So communication with third parties, this is B. It basically is redundant again, based off of the previous section we talked about, so we're not gonna go over it. But 1692 CC, ceasing communication. This is where your cease and desist comes in. So if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer. You could just stop there, that's a violation. To such debt, except, so it says, number one, to advise the consumer that the debt collector's further efforts are being terminated. So they can only communicate with you after you send a cease and desist notice to let you know that, okay, we're done communicating with you. They can't attempt to collect anymore. Number two, to notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such a debt collector or creditor. So I wouldn't worry about 2 or 3 really, but the main one you want to worry about is 15 USC 1692 CC. So this ceasing communication section. This is all I would really worry about as far as, getting your remedy and things like that. Remember, there's a lot of laws, there's a lot of sentences and things like that, but only get what you need, right? So if a consumer notifies a debt collector in writing, if you send a cease and desist notice, which we're going to go over, if you send a cease and desist notice that you refuse to pay that alleged debt, if it's alleged to you, it's alleged to me personally, to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt. So if you let them know, I refuse to pay this debt, they're not supposed to communicate with you anymore, right? And when you tell them you refuse to pay that debt, it's now been disputed. And we're gonna get into multiple debts, which is 1692H. I'm gonna tell y'all something y'all can do. We're gonna tie it to the Fair Credit Reporting Act. So yeah, just be taking your notes and then revisit it later. And if you bought the replay, watch the replay. If you didn't buy the replay initially, then you'll have a chance to buy it later. But yeah, that's the communication section. Any questions on the communication section? I'm gonna take some water and then just continue. All right. So 1692D, harassment or abuse. This is a fun section as well. A debt collector, we know what debt collectors are, right? May not engage in any conduct, the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt. So that already lets us know what's about to go on. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Remember, when you see violations, you circle them, you put them down as exhibits. If it's a phone call, screenshot it, print it out. And then you're going to tie it to 1692K, which we're going to talk about later. So number one, the use or threat. The use or threat of use of violence or other criminal means to harm the physical person, reputation, or property of any person. Let's stop right there. So 15 USC 1692D, right? 1692D, harassment or abuse. 1692D, number one, the use or threat of use of violence or other criminal means to harm the physical person, reputation, or property of any person. The most important part I want y'all to focus on, because a lot of what we're focused on is credit, is your reputation. If you have a negative item on your credit report, your consumer report, whatever you want to call it, is that not a harm to your reputation? That looks like it's a violation of 15 USC 1692 D number 1. So really look at the words and how you can use it and apply it within your specific situation. If you got an inquiry, that's harmful to your reputation. Technically, credit reporting is optional. So you got to understand that, you can really structure your credit report, consumer report how you want to. And then also too, as far as reputation, we're talking about debt collection, debt collectors. If they send you a letter, what if you live with your spouse, significant other, or whatever, siblings, family, parents, whatever, right? That's a harm to your reputation, because they're letting you know that, you owe this alleged debt. So, that's a violation you can use. So 1692 D number 2, the use of obscene or profane language, or language the natural consequence of which is to abuse the hearer or reader. Obscene or profane language, you, the consumer, you determine that. To me, if I look at a letter and it says this is an attempt to collect a debt, that's obscene or profane language to me. To me, you're cursing me out by saying that I owe a debt. So to me, I'm going to use 1692 D number 2. That's a $1,000 violation, because you can't say I owe a debt, because I know I don't owe a debt. I know I'm the original creditor. I know I extended that credit to myself, right? So obscene or profane language is up to you. If you see an amount, a dollar amount, if that's obscene or profane language, that's obscene or profane language to you. So really understand that. Number 3, I wouldn't worry too much about it. Number 4, I wouldn't worry too much about it. Number 5, causing a telephone to ring. So we'll stop right there. That's basically just giving you a phone call. If a debt collector gives you a phone call, that's a violation of 1692 D number 5. You can get them for $1,000. There's also something called, I think it's a TCPA. I think that's $500 per phone call violation. So you can get them in multiple violations. You can get them in 1692K, or you can get them in I think it's TCPA. Do more. You could look it up and confirm that, but yeah, that's a violation as well. So 1692D, harassment or abuse, it has, these violations you can use. There's obviously several violations that we're looking at. So what was I gonna say? Any questions? Let me know. Let me know. No questions so far? Okay, harassment or abuse. There's a lot of violations here. And I also have, I forgot to let y'all know. The people watching the replay, if you're watching the replay, this does not apply to you, because you should have came to the live class. But those of y'all that's here in the live class, there's like a cheat sheet I have that walks through the entire FDCP on one page. So it's just easy to look at. So I'm gonna email it out to y'all. And then, y'all can have that. Maybe I'll show y'all at the end too, just for the people that's on the replay. All right, so 1692E, 15 USC 1692E. I think I covered it briefly on a podcast, but we're really going to talk about, as far as disputing a speeding ticket. I gave enough information to start on the podcast, but like I said, the class is for deeper things I cannot talk about in public on a podcast. Oh, the podcast is about to go live actually in like 6 minutes. Make sure y'all tune in to the New Cap podcast when y'all get off this class. I interviewed my friend Precious Price. She's talking about Airbnb, and she's gonna really, help y'all get started in Airbnb. But that's besides the point. 15 USC 1692E, false or misleading representations. Let's get straight to it. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section. So number 1, the false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge. Does a police officer have a badge? Congress told you police officers are what? Debt collectors, right? So you can get them under this violation if they attempt to collect a debt from you, meaning a speeding ticket. So number 2, this is a violation too. This is one of my favorites as well. The false representation of the character, amount, or legal status of any debt. What's my favorite one over here? Amount. If they send you a letter and they say minimum payment, whatever, it could be $1. That's a violation. False representation, because you know a debt is alleged obligation. They're giving you something that is allegedly yours, right? So that's a violation right there. Remember, each violation is $1,000. We've been here talking about it, maybe like what, 30, 40 minutes talking about it. We haven't even been through all the sections, and we've already found thousands of dollars of violations. So really just understand that, you know, these violations are there. So if they say you owe any amount, that's a violation right there. 3, the false representation or implication that any individual is an attorney or that any communication is from an attorney. What does that mean? An attorney cannot communicate with you. You as a consumer are very, very powerful. So if you get a letter from an attorney, that's an exhibit. That's a violation. I'm pretty sure they understand that. But to be honest, most people don't know the information that we know. Those of y'all that's in this class, you obviously know a little bit about consumer law, at least a little bit about consumer law. And I'm pretty sure you know more than most people know about consumer law. So these attorneys, judges, everybody, they just assume that everybody doesn't, you know this information. People don't know their rights and things like that. And it's sad that's the case, but that's why, you know, at CAT, Consumer Ammunition Tactics, it's our duty to make sure y'all know this information in a digestible way. Because when I first started, you know, learning these laws and things like that, it wasn't as digestible. So when I was learning it, I was like, okay, I know I have to pass this forward. So let me make it in a more digestible way. That's where you get the podcast. That's where you get these master classes. You know what I'm saying? So yeah, that's just a little bit on the goal. So number 4, the representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person, or the seizure, garnishment, attachment, or sale of any property or wages of any person, unless such action is lawful and the debt collector or creditor intends to take such action. So it basically says that they can't threaten you to say that if you don't pay the debt, you know, they're gonna close your account. They can't say that it's gonna result in arrest and things like that. That's a violation. That's $1,000 violation, at least $1,000, right? They can't garnish your wages, things like that. So yeah, just really understand that they're committing a lot of fraud, a lot of violations, and people are just allowing them because they don't have access to the information. Number 5, the threats to take any action that cannot legally be taken or that is not intended to be taken. So they can't threaten to do something that they can't do. And I'm going to give y'all a law that I never spoke about on a podcast or anything that lets you know that corporations, debt collectors, they can't sue you. Right? So pay attention later when I give it to you. You can combine it with, this number 5, and you'll have a powerful dispute. The false representation or implication that a sale, referral, or other transfer of any interest in a debt shall cause a consumer to lose any claim or default. I wouldn't focus too much on that. So just understand it's a lot. If you really go through all of these, for the sake of time, I'm not going to go through everything, but some of these are redundant to previous sections. So if you spend your time going through all of it, you'll really realize that you can get a lot of violations. Look at number 10, the use of any false representation or deceptive means to collect or attempt to collect any debt. Attempting to collect a debt, that's a violation. That's already $1,000 extra over there, right? So yeah, just really understand it goes real deep. It goes all the way to number 16. But yeah, we're going to continue if nobody has any questions on 1692E. And then remember, 1692E is where your foundation for disputing a speeding ticket is. And when I say disputing a speeding ticket, I'm not telling y'all to drive 100 miles per hour, you know, just to test it out or anything. So drive safely. But if you do get a speeding ticket, there is a way because the law. So any questions? I do not condone speeding. Drive safely, drive carefully. But if you got a speeding ticket, there's a way. All right, let's go to F. Again, this is a redundant section, but I just point everything out just to let y'all know, just in case you're missing some of the language. And then we're gonna get into application in a little bit. So debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt. So what does that mean? A debt collector may not use unfair means to collect or attempt to collect any debt. We're going to get into what unfair is, but just within the first sentence, we already have an idea that we're going to get a lot of violations in 1692F. And remember, when it's redundant, when you see something that's similar to previous sections, you can combine those violations. You're just getting more money for, you know, what you're disputing. So keep that in mind. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Number one, the collection of any amount. What does any amount mean? No restriction on the amount. So if you send me a letter that says this is an attempt to collect $1 from me, I just got a $999 return because I'm going to charge you $1,000, right? So the collection of any amount, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. No, there's no law that says you have to pay a debt, so that's irrelevant. The collection of any amount, just stop right there. The collection of any amount. 15 USC, what section are we in? 15 USC 1692F, number one. We go back to the congressional findings. Congressional findings, what did Congress find? There was abusive practices as far as debt collection. We're in unfair practices. It's unfair to collect on any amount of debt because you are the consumer. United States went bankrupt in 1933. Look up the 1933 Act and you'll get more background information. So really just understand that that's a violation right there. That's already $1,000, right? That's the main one I want y'all to know here because a lot of this is redundant, but I like number one. And then I want to speak about repos, repossessions. Number 6. So anybody that has a repossession, if you're dealing with a repossession, look at 15 USC 1692 F number 6. So taking or threatening to take any non-judicial action. What does non-judicial action mean? A non-judicial action means it's not given by, judges. It's not given by the court to affect dispossession or disablement of property if A says there's no present right to possession of the property claim as collateral through an enforceable security interest. There's no present intention to take possession of property. The property is exempt by law from such a dispossession or disablement. So this basically, what the law is basically saying, 1692 F number 6, is basically saying that repos are technically illegal. They're not supposed to happen. So if a repossession happens, the court didn't order them to kidnap your property, right? So if you have a repossession, what you want to focus on as far as the FDCPA is 15 USC 1692 F number 6. So really pay attention over there. Look, number 7 is redundant as well. 1692 F number 7. Didn't we talk about communicating with a postcard earlier? $1,000, right? They don't really do postcards anymore, but look at number 8. Number 8 is going to be a violation for everybody. Using any language or symbol. Didn't we talk about that earlier? Any language. What's a language? This is an attempt to collect the debt. Okay, that's a violation. 15 USC 1692 F number 8. Pursuant to 1692K, I need $1,000. Symbol. Chase's symbol, Bank of America symbol. Why is it on this letter? I'm circling it. That's a violation of 15 USC 1692 F number 8. Pursuant to 1692K, that's a violation. So just really understand there's several violations. The FDCPA, out of the big three, if you don't know, is the Fair Credit Reporting Act, 1681, which I taught already. Truth in Lending Act, which is a 1601 and 1602 definition section. And then the FDCPA, 1692. The Fair Debt Collection Practices Act is probably, in my opinion, where you should start if you haven't started studying consumer law. I think it's the easiest one to understand. And it's just several violations. And the fact that there are many violations, even if you miss some violations, there's so many violations, you're going to rack up a lot of money within your remedy. So yeah, just keep that in mind as you're going through it. Any questions? Any questions? Remember, we're just diving into the definitions. I've covered some of this stuff on a podcast, so a lot of this may be review if you listen to the podcast, but we're going to get deeper into the stuff that, I don't cover on the podcast. I only cover in consultations. Remember, consultations, 30-minute consultations are $350 currently. It's going to go up to $500 pretty soon, but currently they're $350. I think everybody in here used a 40% off code, so you got the class for $120. So you're saving a lot of money, by taking action and being in a course class, whatever you want to call it. All right, so we're going to go to validation of debts. I'm going to give y'all a UCC code, Uniform Commercial Code. That's very similar to validation of debts. That's one of the things I haven't talked about on the podcast. I've only talked about it in consultations, but we're going to talk about 1692G. 15 USC 1692G, validation of debts. So basically, the section 1692G, whenever you're writing your debt validation letter, which is part of your administrative process, you're basically letting them know what they have to do to actually validate that debt. But even though you're reading the 5 things that they have to do to validate the debt, understand that they cannot validate the debt. Only you, the consumer, can validate the debt. So just keep that in mind as we're going through. Notice of debt, contents. Within 5 days after the initial communication with the consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in initial communication or a consumer has paid the debt, send the consumer a written notice containing. Number 1. Oh, before we even continue, like I said, as y'all are going through it, if you want to tag me on your story or something, let the people know what you're doing, let the people know, you're getting the information, go ahead. So number 1 says the amount of the debt. So number 1, they have to say the amount of the alleged debt. Remember what I said about the hyperlinks. When you click on the hyperlinks, it lets you know, it takes you back to the definitions. So the term debt means any obligation or alleged obligation. So get in the habit of clicking on them hyperlinks. So let's go back. They have to let you know the amount of the debt. Number 2, the name of the creditor to whom the debt is owed. Number 3, a statement that unless the consumer within 30 days after received a notice disputes the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. So I have to let you know that too. Number 4, a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector. And number 5, a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor. So I'm gonna give y'all a secret. All 5 of these things, these debt collectors are never gonna give it to you. But like I said, even if they give it to you, the language is very, very important. Even if they give you the 5 things, what does debt even mean? Any obligation or alleged obligation. If it's an alleged obligation, even if you give me the 5 things to actually satisfy or validate the debt, it's still an alleged obligation. I wrote to you, it's an alleged obligation. So it's an alleged obligation. That's the foundation. So really just understand, even if they send you the 5 things, which they won't, it's an alleged obligation. We're gonna walk through my affidavit example. It's an 11-page affidavit. It's asking more than like 50 questions, basically. So you have 5 here, but in the affidavit that I send, it's like 50-something questions. They're not gonna answer every question. So by law, your affidavit is your most important piece of information when it comes to, winning in court and all that. So by law, that affidavit is gonna stand true, because if it's not replied to line by line, it stands as true. So yeah, just keep that in mind as we get into the affidavit. I'll give you guys more information on that. But the validation of debt section, this is basically what they say has to be satisfied. And like I said, I'm gonna give y'all a UCC code, Uniform Commercial Code, because these laws go deeper than 15 USC. There's UCC codes, there's rules, rule 1, rule 2, rule 602. We're gonna go through some rules as well, which I don't talk about on the podcast, but I'm gonna, y'all pay for the class or replay, so you'll get the information. But yeah, don't get overwhelmed. It's a lot of information. Just be taking notes and then revisit it later. Just take action. So B, 1692G, number B. I said number B, letter B, disputed debts. So this is a long paragraph. I'm not going to read the whole thing, but basically all you need to know is that if you notify the debt collector in writing that the debt is disputed. So if you're disputing a debt, it means that they're not supposed to attempt to collect on it. So basically, when we go back to 1692 CC, which is Season Communication, if y'all took notes or just remember, that was basically where we were talking about. Once we let them know that we refuse to pay on the alleged debt, they have to cease communication. They have to stop communicating. They have to cease their collection efforts and cease communication. 1692 GB is an additional ceasing communication section. And I'm also going to give y'all later, it's going to tie to multiple debts. Whenever you dispute a debt and they've received your notice and it's noted that you're disputing a debt, you can use 1692H, which is multiple debts, and you can actually send a notice to invoice them for previous payments. Because if they are attempting to collect on a debt that is disputed, that's a violation. So we're gonna dive deep into it, and it's gonna tie to The Fair Credit Reporting Act. This is a specific section in the Fair Credit Reporting Act. So yeah, so if you're disputing, they're not supposed to attempt to collect on it. Just remember that. 1692G(c), admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability by the consumer. So this is basically saying that if you fail to say that the debt is yours, it shouldn't be misconstrued that you're liable for that debt. So what does that mean? Isn't Congress looking out for you? Congress is looking out for you because usually it's like ignorance or law is no excuse, but the fact that they're saying that if you fail to dispute the validity of it, it shouldn't be misconstrued as saying in court that you do owe that debt. So Congress gave you all the power. They gave y'all a cheat code by saying that even if you fail to say, oh, this ain't my debt, they can't say like, oh, you didn't say it's your debt, so now it's your debt. Admission of liability. So 1692G(c), that's a powerful section as well. Pay attention to that one. So that's pretty much validation of debt. Like I said, I'm going to give y'all an additional validation of debt UCC code. But that is that. Any questions? Any questions? I've been talking. I need a water break. So we're going to go to 1692H. I got to go over here because it acts weird after you get to 1692G. So we're talking about multiple debts. Multiple debts. So this is a section you want to pay attention to as well. I haven't really covered it deeply on the podcast because, I don't want it in the wrong hands. But if any consumer owes multiple debts and makes any single payment to any debt collector with respect to such debts, such debt collector may not apply such payment to any debt which is disputed by the consumer and where applicable shall apply such payment in accordance with the consumer's directions. All right, let me read that one more time and then I'm going to break it down on what it means if y'all aren't following. So 1692H, multiple debts. If any consumer owes multiple debts and makes any single payment to any debt collector with respect to such debts, such debt collector may not apply such payment to any debt which is disputed by the consumer and where applicable shall apply such payment in accordance with the consumer's directions. It might sound crazy, but this is what Congress is saying. Let's say you send out a notice and you're disputing the validity of a debt. So you send out your debt validation letter. Because you sent out your debt validation letter, this is now a disputed debt. So let's say, oh, the minimum payment comes around again. If you make that minimum payment, they're not supposed to apply that minimum payment to the account because you disputed the debt. Because it's being disputed, it's supposed to be applied based off of your instructions. The reason why they say multiple debts is like we made multiple payments. Because it's supposed to be applied in terms of your instructions, what you can actually do is send a notice to them because it's disputed, let them know because it's in accordance with the consumer's directions. You can let them know to send you that payment and the previous payments you made to you via check, to your bank account or whatever. So it's up to you as a consumer. Remember, all this stuff is prepaid, right? So it's up to you and your directions. So the way that you're actually going to do it, you're going to use 15 USC 1692H. You're going to combine it with the FCRA section, 15 USC 1681I. So 1681I, it talks about basically, when you're disputing the process, when something is disputed, they're not supposed to be attempting to collect on, that debt and things like that. So write down 15 USC 1681I and use that section with 1692H. So multiple debts. So that's some sauce right there. A lot of people don't know about that and how you can combine those two sections. You're supposed to, you're not supposed to, you can instruct them when you dispute that debt because it's based off of the consumer's directions to send the debt over, to send the previous payments you made over to you. I'm not saying that it's going to happen like that. A lot of times, like I say, you got to apply pressure and take them to court. But as long as you show these things through paperwork, you'll be able to get your desired result eventually. Because you got to think about it, just because you send an invoice, just because you send 1692H, you're showing them the law, they're going to continue violating the law unless you apply pressure. So this is why we're talking about litigation today or tonight, whatever. Any questions on 1692H? 1692H. All right, we're going to go to 1692I, remember I said it acts weird, so I gotta go to the actual, hold on. Okay, I gotta go to the actual thing over here. Okay, this is a redundant section again, but just extra violations to rack up. So legal actions by debt collectors. Remember, I'm gonna give y'all a law later that shows you debt collectors cannot, they're not allowed to sue you. There's a specific law that gives you that. I haven't talked about publicly besides consultations. So venue, any debt collector who brings any legal action on the debt against any consumer shall, in the case of an action to enforce an interest in real property, securing the consumer's obligation, bring such action only in the judicial district or similar legal entity in which such real property is located. So they're basically saying that they have to sue you where you live, basically. That's basically what it's saying. And in a court, judicial. In the case of an action not described in paragraph 1, so not applying to paragraph 1, bring such action only in the judicial district or similar legal entity in which such consumer signed a contract sued upon. So wherever you did business, B says in which such consumer resides at the commencement of the action, you know, where you were at the time of that transaction that they're attempting to sue you for. But remember, they're not, they can't sue you. If you get sued by a debt collector, you should be smiling because you understand, well, you're gonna understand if you don't know already, the law I'm gonna give y'all that y'all wanna write down to use against them if they attempt to sue you. In the authorization of actions, it just says nothing in this chapter shall be construed to authorize the bringing of legal actions by debt collectors. So yeah, they're not supposed to sue you. But if they attempt to sue you, I'm giving y'all the protection on how to go about that. Any questions on, you know, this one? All right, let's go to HIJ. So we got 2 more and then we're gonna get deeper into examples and stuff. So this is just a literacy aspect. Oh, I didn't mean it. I meant to open an additional tab. Hold on. Furnishing certain deceptive forms, legal actions by debt collectors, furnishing certain deceptive forms. This applies to everyone, right? Chase, etc. Yes, it applies to Chase. If they're attempting to collect a debt from you, they are a debt collector. So yes, it applies to them. Our 1692J, furnishing certain deceptive forms. Furnishing certain deceptive forms. So A, it is unlawful to design, compile, and furnish any form knowing that such form would be used to create the false belief in a consumer that a person other than the creditor of such consumer is participating in the collection of or an attempt to collect a debt such consumer allegedly owes such creditor, when in fact such person is not so participating. So a simple example I can give y'all. This goes back to TILA, Truth in Lending Act, which is 15 USC 1601, but 15 USC 1602 is a definition section. So when you have your car contract, if you go to your car contract right now, it's going to say original creditor and it's not going to say you. That is a deceptive form. So that's a violation of 15 USC 1692J because of the fact that you are the original creditor. You extended the credit to yourself. The FDCPA is not the section for us to break down, you know, the fact of how you're the original creditor, but just understand, take notes, 1692J, that applies to your car contract. So when you circle on your car contract, the original creditor, that's deceptive, right? Because it's as if you're not the original creditor, right? So anything is, anything that says you're not the original creditor on that car contract is a violation. An additional violation is if they don't give you like a certain disclosure. So omitting something from a certain process, that's a deceptive form. So just really be thinking about, you know, things that you get and what is a certain deceptive form. A deceptive form, what's a deceptive form? An example of a deceptive form, because they say any form means no restriction. An example that I want to give y'all as well, they send you a letter saying that you owe a debt. If it's an alleged debt, that's a deceptive form because they're making you think that you have to pay something that you don't have to pay, right? Because you're not paying on a positive balance. So you got to really understand that. B, any person who violates this section shall be liable to the same extent and in the same manner as a debt collector is liable under section 1692K of this title. We're going to go to 1692K next. That's where the money is. For failure to comply with the provision of this subchapter. So 1692J, pretty self-explanatory, just additional violations for y'all to get them under. The main example that I've seen, dealing with people is just the fact of, your car contract. So when it comes to rescinding that car contract, that 1692J is what you want to be aware of as far as part of your exhibits. That's only a small portion of the whole process, but that's a different conversation for a different day. So this is 1692J. I'm going to go to K if there are no questions, and then we're going to continue. So civil liability section. So you see 15 USC 1692 goes all the way to P, but I'm telling y'all, only use what you need. You don't need to get too deep into it. I used to be falling victim to getting so deep with, all these laws and things like that, but it's like use only what you need. So civil liability section. So if you don't know about civil liability, 15 USC 1681N is a civil liability section for the Fair Credit Reporting Act. So if you watch the Fair Credit Reporting Act, or if you just know about it, that's civil liability section. 16810 is also a civil liability section. So the Fair Credit Reporting Act has two civil liability sections. The Fair Debt Collection Practices Act, which is what we're talking about today, it has one civil liability section, which is what we're talking about right now. The Truth in Lending Act has one civil liability section, 15 USC 1640. So Truth in Lending Act, that's going to be a separate class that we're going to talk about. But I just want y'all to be familiar with, the different civil liability sections. So amount of damages. Except as otherwise provided by this section, any debt collector, any is no restriction, right? So someone asked about Chase earlier. Chase is, if they're attempting to collect a debt from you, they're a debt collector. Any debt collector who fails to comply with any provision of this subchapter with respect to any person is liable to such person in an amount equal to the sum of any actual damage sustained by such person as a result of such failure. So an actual damage is dependent upon you. For me personally, if you're using obscene or profane language, that's a damage to me. That's harmful to my reputation. You're saying I owe a debt I don't owe. You put something on my credit report or my consumer report, that's harmful to my reputation. That's an actual damage. You put something on my credit report, it's aggravated identity theft because I did not give you consent to put it on there. That's a damage, actual damage, right? So it's really up to you to determine what an actual damage is. So in the case of any action by an individual, such additional damages as the court may allow, but not exceeding $1,000. So that 2A is where you understand when we say it's $1,000 per violation, where it's $1,000 per violation, right? And when you're doing it, when you're suing in district courts, the max you can get is $75,000 you can sue for. But there's a further relief section, which is, and this goes deeper, or we're going to go deeper into it. It's 28 USC 2201. There's a further relief section if you want to sue for more than $75,000. That's what you would use. But yeah, we're gonna go deeper into that in a little bit. But I don't want to give y'all too much information to where you won't take action. When it comes to litigation, we're going to talk about litigation in a little bit. We're looking at 1692 KD, right? So a lot of people, this is where a lot of people just focus on. A lot of people just focus on, any actual damage right here. A1, 2A, etc. But when we're talking about actually taking action, like I said, I haven't mentioned this on the podcast because, I don't know who's serious, right? You guys invested in the class. I know you're serious. So let me tell y'all what we actually focus on when it comes to taking these people to court. 1692 KD, jurisdiction. An action to enforce any liability created by this subchapter may be brought in any appropriate United States district court without regard to the amount in controversy or in any other court of competent jurisdiction within 1 year from the date on which the violation occurs. So amount in controversy, this is basically the amount that your remedy is, what you're suing for, and you would state it in your affidavit. So just keep that in mind. So 1692 KD is what you want to focus on when you're going about your remedy. So before we get a little bit deeper, are there any questions? We're going to get into the administrative process. We just got into the literacy aspect. We're just getting started. So I hope y'all aren't sleeping. That was only the beginning. And that should have been reviewed to a lot of y'all, to be honest. If it wasn't reviewed, don't be discouraged, because I know not everybody knows about the law, but that was really only the beginning. Any questions? Okay, we ready to get into the real stuff, huh? All right, so let's get into the administrative process. Hold on. I could leave this open. I don't need to leave this open anymore. We already reviewed everything. Okay, so we're gonna get into the administrative process. So this is a process, not the process. This is a process, not the process. So administrative process. What you're gonna do, anytime you're dealing with a debt collector, what you wanna do is send a debt validation letter. So you can send a debt validation letter pursuant to 15 USC 1692G, which is what we talked about earlier. And then also, like I said, we're gonna look at UCC 9-210. I haven't talked about it. Not a lot of people use it, but it is something you can use. On top of the debt validation letter, we're gonna send a notice to cease and desist. So 1692CC, or you can use 1692CC, or you can use 1692GC as well. Just letting them know to stop attempting to collect on the debt. And the reason why I bolded notice, sometimes some people just send a letter and they say cease and desist. You don't want to do that. You want to put notice. Remember, language is very, very important. You want to put notice to cease and desist. The reason why you want to put notice instead of just putting cease and desist is because the word notice allows it to be something that's used in a court, right? If you're just putting cease and desist, it doesn't technically mean it's going to help within your case. So you want to put the word notice. Just that piece right there. I don't think I've talked about that on the podcast. I only want to give information to people that are serious. So remember to put the word notice when you're writing your cease and desist. So once you send that debt validation and your notice to cease and desist, let's say it's 14 days, 30 days you gave them, right? When it comes to UCC 9-210, the reason why I like using UCC 9-210, which is a different form of validation of debt, it allows you to say they have to respond in 14 days. And remember what I said about time. Time is very, very important. We don't have time to be waiting left and right for them to reply to us, right? So we want to get straight to it. So once that 14 days, 30 days happens, where we sent our debt validation and our notice to cease and desist, we want to send it certified because we want to make sure when they receive it. When you send it certified, you're going to know that they received it. And then number 2 is optional, which is what I talked about earlier. You can follow up with the multiple debt section, 15 USC 1692H multiple debts. Why can you follow up with the multiple debt section? Because you disputed the debt by saying, I need validation, I need verification of this debt. Once they receive it, that debt is now in dispute. Any item in dispute on your credit report pursuant to 15 USC 1681I, they're not supposed to be attempting to collect on that debt. So now what I'm gonna do, I'm gonna send you 1692H multiple debts. Please redirect my previous payments and this a payment that I just sent and apply it to me. Send it to me via check or whatever. So that's an optional thing you can do. You don't have to do all that. You can do that in your invoice later, but that is something that you can do. After that, it's gonna be your affidavit, right? You're gonna send your affidavit. So this is technically like step 2 or step 3 if you do multiple debts. So the affidavit, the whole purpose, this is your most important document when it comes to winning your case. The affidavit is important because it's going to show your exhibits, right? It's going to point out how they didn't provide an authenticated record by law. Authenticated record is more of language used in the UCC 9-210, which we're going to look at. But they didn't provide validation. That's basically what your affidavit is going to talk about. And you're going to point out to them how they're violating the cease and desist notice, if applicable. And in the affidavit, I'm going to show y'all an example. And keep in mind with the example that I'm going to show y'all, I do not sell that. I do not sell the letter only to people. I only give it to people that have been on a consultation because I know you're serious if you book a one-on-one consultation. So I'm going to give y'all like a preview just to give y'all an idea of what you should put in your own affidavit. But understand, if you got the Fair Credit Reporting Act Masterclass, I went over like what to include in your affidavit of truth. But the affidavit I'm going to show you here is a deeper affidavit and it has everything you need to do just to get everything, right? So you'll see that it's a little bit different from what you saw in the Fair Credit Reporting Act class. So after that, remember your affidavit is your most important document because it's really where you're it's really where you're seeking a default judgment based off of Rule 55, which is what we're gonna talk about. That's one of the laws that I haven't talked about on the podcast. I only reserve it for people that are serious. We're really talking about litigation here because I want y'all to get y'all desired result, whether it is a deletion, if it's collection, charge off, whatever, or if what you want to get is remedy, right? Because, you know, you could get paid off of these people. So we're going to send a notice of default. So basically what we're going to do is we're going to let them know again that they failed to provide you the information in the allotted time, whether that is 14 days, 30 days, etc. And, you know, it's going to be a violation of 15 USC 1692G if you choose to use that section, or it's going to be a violation of UCC 9-210. I like UCC 9-210 because, like I said, the law says they have to reply in 14 days. That 1692G says 30 days. I like a faster approach. It's up to you what you use, right? And then, you know, you're going to have an opportunity to cure. So you're going to send them that letter. And then you're basically going to reference a previous notice that you sent them. Remember, notice is very, very important. The word notice, like I said, notice to cease and desist, notice to do this, notice to do this. Notice can be used in court. Language is very, very important. So you're going to send your opportunity to cure. And it's basically a final attempt at resolving the issue, whether you want a deletion or if you want to, you know, get paid for them violating you and your rights. So an example of opportunity to cure that you can, example law is 15 USC 1681 S-2. It's basically talking about when you've showed them that they have reasonable cause to believe that the information that they're reporting is inaccurate. So you can use that law in your opportunity to cure. If you don't get your desired result, we don't got time to be going back and forth with these debt collectors. Nothing is saying that you can't sue these debt collectors. So then we get into litigation, all right? So we're gonna get into it. I'm gonna get y'all started as far as it. And then if you want more information, obviously, you know, when you're suing somebody, you can get thousands upon thousands of dollars. I don't think it's crazy to let y'all know. If y'all want, you know, assistance with the process, you're gonna have to book a consultation. What is $350 to, you know, what you're gonna get in court, right? So just keep that in mind. What I want to say, going back to what I said in the beginning, this is a process, not the process. So my point in saying that, your affidavit, this is how I do it. Now, just over time, I've, you know, changed the process. I used to do the administrative process just like this, right? Send a letter, wait for them to reply, send a letter, wait for them to reply, send a letter, wait for them to reply. Your affidavit can include everything. So you can send one notice and then just get straight to suing them if you want. So affidavit can include the notice of default, and it can include opportunity to cure. You can warn them in one letter, everything that they have to do, and it includes your debt validation. So your affidavit can include literally everything. You can do everything in one notice because we don't have time to be going back and forth with these people that don't want to, you know, stop harassing you. So you can do it and then get straight to litigation. I just want y'all to know that. And then one thing too, a best practice, I want y'all to look up the registered agent address of the debt collector. I want y'all to look up the EVP, which is executive vice president if you can. And I want y'all to look up the general counsel if you can. The general counsel is basically like the attorney or whatever for that company. So when it comes to looking up those, you're gonna see on the affidavit example, you're gonna basically send out the letter to them as well. You wanna put everybody on notice. This is how it works to the best of your ability. So this is why we do things like state attorney general complaint, CFPB complaint, things like that. I wouldn't focus too much on the CFPB complaints and things like that. You just want to use it as a paper trail. Don't rely on them to help you. Take these people to court, sue them, right? So that's what I would recommend to y'all. And then a lot of people don't know, but you can notarize with or without the United States. So notarizing with or without the United States means that you can, if you're doing it without the United States, basically you don't have to go through a notary. You don't have to get the document notarized, right? So this is a power you have as a consumer within, you know, United States. So a lot of people don't know it's more than one United States. So this is why it's important to study these laws, and it's important to invest in things that I have because, you know, I'm studying these laws so you can just follow my lead or whatever, but it's important to understand too. So when you're signing without the United States, it's 28 USC 1746, number 1. The thing that you have to do, you have to quote Matthew 18:16, and that basically talks about having 2 witnesses. And you know, that's obviously from the Bible. A lot of people might think like, oh, you know, is it a religious thing? It's not necessarily a religious thing. It's just that the Bible is the law of the land. Let me give y'all an example. There's a public law you can look up. I forget it off the top of my head that lets you know the Bible is a law of the land. But an example as far as how the Bible is the law of the land is basically Like, let's say you have a debt and they say, you know, with credit, on your credit report, your consumer report, it's 7 years and then it falls off. It literally says in the Bible, after 7 years, stop collecting on, you know, a debt. So that just goes to show you a lot of these policies, the Bible is a law of the land. So when it comes to notarizing without the United States, you're going to quote the scripture, Matthew 18:16. So write that down. If anyone has heard me say, go this deep on a podcast, let me know. I'll send you $10,000. You know what I'm saying? So yeah. So let's look at 28 USC 1746, number 1. I just want to show y'all the notarizing real quick. So this is 28 USC 1746. Remember, I said it goes deeper than 15 USC. 15 USC is what you'll get on a podcast. When you get in classes, private stuff like this, you're going to get more than Title 15. So 28 USC 1746, this lets you know how to actually notarize your affidavit. So number 1, this is if you're executing without the United States. This is what I was talking about. So if executed without the United States, you write the same thing as what you write on number 2. But the main difference, like I said, 28 USC 1746, number 1. Number 1 says if you're notarizing without the United States, you have to have 2 witnesses. 2 witnesses, and you have to quote the scripture, Matthew 18:16. So that allows you to notarize without a notary. So you don't have to notarize with a notary. You can notarize without the United States. If you notarize with the United States, then that's your typical affidavit where you get a notarize. You go in front of a notary, they sign it, stamp it, all that. But if you want to notarize without the United States, 28 USC 1746, number 1. When it says 2 witnesses, you know, that's up to you, whoever that is. So yeah, just really understand that. Do more research on that on your own. That's more independent study stuff. I just wanted to expose y'all to that because, you know, you invested in the class. I want to give y'all the bang for your buck. I think everybody here using the code, you invested $120. I hope by the time we're done with the class, you think $120 was worth your time being here. All right, so I also want to show y'all the UCC code I was talking about. So this is a different form of affidavit. This is a different form of a validation of debt. So UCC is Uniform Commercial Code. And Uniform Commercial Code is commercial law. Courts that use commercial law. So these laws are very, very powerful. So UCC 9-210 is request for accounting. You as a consumer, you have a right to request for accounting. What is a request for accounting? The one I want you to focus on is UCC 9-210, number 2. So UCC 9-210, number 2 says request for accounting. Request for accounting means a record authenticated. That's all I want you to focus on. A record authenticated, right? So an authenticated record means that it's signed by an official. So if you send out a debt validation letter and you decide to use UCC 9-210, what you're telling them is that they have to give you a record authenticated. So when they send you something that is a statement saying that, oh, these are things you paid and all that, it wasn't signed. It wasn't authenticated by an official. It has to be authenticated by an official, and they're never going to do all that. Why is that so powerful? Because they're never going to do all that. That means they didn't adequately validate the debt. You have a right to request for an accounting, right? So because they're not going to send you a record authenticated, that now becomes the fact that they didn't answer adequately to your affidavit. So you put this in your affidavit, how they didn't answer it, and now your affidavit stands as a truth. So you can use 15 USC 1692G for your validation of debt and your debt validation letter, or you can go to Uniform Commercial Code. You can use UCC 9-210, request for accounting. And like I said, the reason why I like UCC 9-210 is because of speed. Let me show y'all in the law where it says 14 days is when they have to reply. So a person that receives a request for accounting for authenticated record, look right here. Within 14 days after receipt, by saying the debtor an authenticated record. So basically it's saying when they receive that notice, they have to reply in 14 days versus 30 days in a 1692G. So that goes a little bit deeper beyond the scope of Fair Debt Collection Practices Act, but UCC 9-210 is related to debt. So that's why I wanted to include it in the class. and just reward y'all for investing in yourselves. So that's UCC 9-210. And we also went over 28 USC 1746. So, notarizing without the United States. So now what we're going to do is we're going to go through the example affidavit. And then we're going to go over invoice and other stuff. How y'all feeling? Are y'all with me? Let me know if y'all awake. Let me know if y'all sleeping. Let me know what y'all doing. Hopefully y'all awake. If you're sleeping, if you're missing anything, hopefully you bought the replay or you buy the replay. All right, so like I said, you can put everything in one notice. Everything can go in one notice, right? So this is your affidavit. This is the 11-page affidavit that I use personally. Like I said, I don't trust everybody to take action. So I only give this template to people that booked a consultation. So if you booked a consultation, then you can get this affidavit. But if you didn't book a consultation, then you obviously don't have the affidavit. So let's just walk through it real quick, and then we're gonna go into the next section. So notice to agent is notice to principal, notice to principal is notice to agent. If you don't know what that means, this basically just means when you send out this affidavit, the notice to agent is notice to principal is notice to agent. It means that by law, it's supposed to get to the right person, the right department. So for example, sometimes when you send out these notices, it gets to the clerk, the front desk clerk. That's not even the right department. It could be the wrong department. But when you put notice to agent is notice to principal is notice to agent, it's a binding document. It has to get to the right person. And then I put silence as acquiescent. I put silence as acquiescence. What does that mean? That means if they don't reply, it stands as truth. But it doesn't just go there. If they don't reply line by line, it still stands as truth because they didn't refute it correctly. An affidavit has to be refuted line by line in order to be refuted adequately, but they're never going to do all that. If they won't do it on a simple debt validation letter that might be 1 to 2 pages, you think they're going to reply line by line to my 11-page document? No. So yeah, put the date, put your name and address, put the debt collector's name and their address. And then this is why I say you want to look up the registered agent. When it comes to, getting your desired result and doing this effectively, you're going to have to do research. So you might be like, how do I get the registered agent? Google the Secretary of State, right? They should be registered as a business on the Secretary of State. Where do they do business? You'll find a registered agent. You'll find a registered agent address, right? You can search the Secretary of State website in the state that they're registered in. So you should know where they're registered in, obviously. You can also search their trust indenture. So just really understand that. Okay, hold on, let me scroll down. My picture is in the way on the Zoom. All right, so if you do have the document, you want to keep this in there. And then you would say you, private woman or man, you would put your first, middle, and last name. You would just say, basically like in a normal affidavit, that what you're about to say is facts and to the best of your ability. And then what we put is within 14 days of receiving this document, they have to reply. If they don't, it's they didn't reply to it adequately. So now they're in trouble, right? And then remember what I said. A lot of people just say, 15 USC 1692K, that's how you get money. But we're looking at 15 USC 1692K D specifically, right? So we're looking at D specifically. So basically, once I say that, I tell them I'm looking for a Rule 55 judgment, Rule 55 default judgment. We're gonna get deeper into that, but Rule 55 judgment, default judgment. This means that if they don't reply, I'm looking for a default judgment. I'm gonna get my remedy. So that's how you want to look at it as. Remember, this is an 11-page document. So then I say I require proof of the following to authenticate, this account. So 1692C, proof of your permission to contact me regarding this debt. Obviously, we didn't give them permission, so they can't even prove that. Number one, they can't even prove that. So it's like they can't even refute the document. But we asking them over 50 questions here. Proof that I gave you permission to speak to me as a communication from an attorney is illegal. 1692E number 3, go back to that. That's illegal, right? And then, it just goes on to say different things that they have to satisfy. And like I said, I give this to people that have been through consultations. If you haven't been through a consultation, you can book a consultation. I'll give you this example. That's how I'll know you're serious. But yeah, it asks all these questions. We go through like over 50 questions. And then basically At the end is where you certify. Remember, your signature is very, very powerful. So if you're certifying, if you're notarizing without the United States, 28 USC 1746 #1, that's what you'll say here. So I notarize without the United States. So that's what you'll put there. And then I just put John Doe as an example. Like a normal affidavit, you'll say the day and the month. And then you'll say attached exhibits of violations and invoice for violations. So exhibits are everything we did earlier, right? Everything we did earlier as far as identifying the violations and things like that. Also, I just remembered I got to show y'all the PDF I'm going to send y'all. Those of y'all in the live class. So I'm going to do that in a little bit. But yeah, basically this is where they are supposed to sign. They're not going to answer everything, but this document is all you need to send. We're going to get into litigation and what you need to send as far as getting your desired result. But you want to send an affidavit that has everything if you want to do it quickly. Or like I said, it's nothing wrong with doing the administrative process where you send your affidavit, then you send your notice of default, then you send your opportunity to cure, and then you go about litigation. But you can literally, this 11-page document, it literally has everything in it. I just sent one notice and then now it's litigation. And then as far as authenticating your own signature, just a best practice, you want to sign in blue ink. Use a blue pen when you're signing, when you're signing with your name. Do not use a black ink because black ink represents a dead entity. Blue ink is certifying it that you're signing it. And then what an additional thing you can do to authenticate it, you can get a red ink pad. Red ink pad, thumbprint. Your thumbprint is very, very powerful. Thumbprint and then stamp it. So that really certifies the document. So that's what you send out. Once you send that out, they're not going to reply to it within that 14 days. And then that's when we get into litigation. But before we even get into litigation, I want to walk y'all through the whole invoice thing. But before we get into that, I want to show y'all the cheat sheet thing I was talking about. So this document, it literally has everything we talked about today. And I'm going to send it out to y'all. And it's just a way to, look at everything on one simple page. So those of y'all that's here on the live class, you're going to get this. If you're watching the recording, maybe screenshot, I don't know. But just a treat for the people that came on the live class. So I'm going to email that to you guys when we finish the class. You'll get it within 48 hours. So we went over the affidavit, right? So affidavit is finished. Like I said, I don't sell this document, so don't ask me for the document. If you book a consultation, then I can give you the document. We can walk through it and make your disputes more powerful. So this is done. Administrative process, I can leave that up. But now we're going to look at the invoice, and then we're going to get into litigation, and then we're going to get into charge-offs and stuff like that. So yeah. So your invoice, everything in the law is language. Remember, everything in the law is language. So you want to title your invoice bill of particulars or true bill. So what does bill of particulars mean? It's just a formal way to present your invoice in common law, which is what we're in. It's an itemization of the claims in a lawsuit against the defendant. Remember, the debt collector is the defendant, you're the plaintiff, you're suing them, right? So you want to title it bill of particulars. Or true bill. True bill is decision to indict the defendant. So you're saying that they're committing criminal activity, basically, or they're committing a violation against you. So you want to call it what it is. These are law terms you want to use. You don't want to just, in the beginning, I used to just say invoice, You could say invoice, but this makes it more official. So on the invoice, you'll put the date on the invoice. Then you'll say, this is an invoice for the violations. And you'll let them know, please remit the payment to the address on the true bill within 10 business days. It's up to you. You can do 7 or whatever, but this is an example. And you'll say, attention, debt collector name, and you'll put their address. And you'll put your name and your address. And then this is how I would structure it. You'll put the description of the violation, the quantity, the unit price, and the cost. Someone got a caught in my mouth, my bad. So 15 USC 1692B number 2. So if that's a violation, if they violated me 2 times, the unit price is $1,000 per violation. It's 2 of them though, so the cost is $2,000. 15 USC 1692 CC. They violated my cease and desist, right? They did that 5 times. Unit price is, well, it should say unit price is 1,000. That's my bad. Unit price should be 1,000, but that was 5 times. So $5,000 violation. 15 USC 1692 D number 2. One time violation, $1,000. $1,000 how much it costs. Escalator fee, which is basically a late fee. It's up to you what you determine that to be. It could be, sometimes when I put in my letter, I'll be like, it's $50 a day or $1,000 or something like that for the month, right? So you could make it $1,000 and then, you know, that's $1,000. So you'll put the subtotal and then you'll put the total, and it's $9,000 in this example. Then you'll say, thank you. The remedy is being pursued in relation to Rule 55 of the Federal Rules of Civil Procedure and 28 USC 2201. When we get into litigation in a little bit, we're gonna get deeper into that. But this is basically how you wanna structure your invoice. And then you're gonna put your name, beneficiary. In law, beneficiary is a person, you know, receiving the remedy. So that's why you wanna structure it like that. Any question on the invoice? Any question on the invoice? How are we feeling? Are we awake? Are we sleeping? Let me know. This is how you can structure your invoice. So we're gonna get into the charge-offs, deleting charge-offs, just something extra you could do. And then we're gonna get into litigation and then miscellaneous info. And then we're gonna call it a night after y'all have questions, if you guys have any questions. Okay, no, there's a question. Can you invoice them for deletions too, since it's technically an omission? Oh yeah, that's something I wanted to say. I think I was going to cover it later. But yes, you can invoice them for the deletions, because what you want to do with your invoice, okay, this is what I should have said. What you want to do with your invoice is you want to invoice them as soon as an action happens. So let me expound on that. You want to invoice when an action happens. When you get a deletion, that is admission. So that's when you're invoicing them. But if I don't know if your question is saying if you invoice them before you get a deletion and you invoice them after you get a deletion, I don't do that. I wouldn't do all that. But basically, when you're invoicing them when an action happens. 2 actions. One action is they delete the information. A second action, they don't reply adequately to your notice. They ignore your notice. That's an action. They took an action to not reply. So you invoice them. So whether it is a deletion or they don't reply, you can invoice them. So yes, you can send an invoice after they delete, because that is an action. Technically, you're supposed to send an invoice after an action happens. An action can be when they delete it, because that is admission. An action can be they didn't delete it and they ignored you, right? So basically, let's say you sent a notice to them and then they didn't delete it and they didn't reply in time. You can send that invoice, because them not replying in time is an action. Let's say you send a notice, they do delete it. They admit it. So now you want to go back and invoice them. But as far as charge-offs. So charge-offs, I think we all know. If you listen to my charge-offs episode, you do know. Charge-offs are basically income. So it's not supposed to be reported on your consumer report. Because income is not supposed to be reported on your consumer report, it's inaccurate information. So we're obviously going back to the Fair Credit Reporting Act. So charge-offs can be very, very stubborn sometimes. So one thing that we've been doing within our business as far as credit repair, sometimes what we'll do is we'll send out IRS tax fraud forms. And this is something you can implement within your own pursuit if you're helping someone get a charge-off deleted, or if you're deleting a charge-off yourself. So this IRS tax form that you're going to want to send as far as IRS fraud is a form 3949A. So basically, you're going to fill out section 2, which is about the business. Let me pull up the form. Hold on. Okay. So yeah, let me max out my screen. So if you got a debt collector, charge off, whatever, you're going to skip number 1 because it's not about an individual. Number 2 is going to be the name of the business. So you're going to put their information. And then number 3, you're going to describe the violation. So it's really up to you. But what we do is a lot of these boxes you can check. The one that we choose is we check false exemption, false deductions, failure to withhold tax, failure to file return, and other. So like I said, it's up to you what you decide to choose. But, that's what we do. The whole purpose of filling out this form is letting the IRS know that they did not send you your 1099-C, because this is the approach you want to do with a charge-off. Whenever you have a charge-off, you want to request a 1099-C form because the company wrote off your debt and they're supposed to have filled out a 1099-C form. If they didn't fill out a 1099-C form, they're committing tax fraud. So this is why if you send out the notice and they don't send you that 1099-C, which happens a lot of times, take it directly, send a notice to the IRS for tax fraud. I'm not saying the IRS is going to do anything, but it helps when you're filling out a form where they do business to the Attorney General. You let the state Attorney General know in your complaint. You filled out an IRS tax fraud form. You put in your CFPB complaint and other complaints. I'm just giving y'all an extra measure as far as, this is related to the scope of debt collection. So this is what it is. If you don't have charge-offs, you don't deal with charge-offs, just sit through what I'm talking about right now. But yeah. So like I said, number 3 is where we check those boxes. Number 4 is where you would skip. Number 4, you would skip it. And then number 5 is where you describe what happened. So this is how we do it. We say, so this is after we sent a 1099-C form. I requested my 1099-C form that should have been given to me by insert the name of the company, but they failed to give it to me. So it is under my assumption that they have committed tax fraud by not filing. The account number for this reference account is XYZ. If they did file a 1099-C form and just didn't give it to me, it needs to be deleted from my insert the credit consumer reporting agency it's reporting on, wherever it's reporting, because it's inaccurate. Since per the IRS, it is now classified as income, and income is not supposed to be reported on a consumer report. So that's what you would put in number 5. So this is what you would put. And then number 6, additional information, you can skip that. Number 6, you can skip that. And then section C, number 7 is about yourself. So you put your own information, whatever applies. So if you're doing it for a client, put the client's information. And then you're going to print the form and send it to the IRS. So you're going to IRS, can I highlight this? Oh yeah, I can. PO Box 3801 in Ogden, Utah. So you're going to send that out and you have notice that you've sent it out to the IRS. So mail to Internal Revenue Service, PO Box 3801, right? And then once you do that, in my opinion, the next step will be litigation. Because the whole point of litigation is you attempted to resolve the issue that you have with them in private. So this brings me to my next point. Let's talk about litigation. Anybody have any questions about the charge-offs? Let me know. That was just a quick walkthrough. I don't think anyone has questions, but if you do have questions, go ahead and let me know. Or we're gonna get straight to litigation. This is the fun part. We're gonna get straight to suing these people when they're not acting right, which is 99% of the time. All right, so litigation. So when it comes to litigation, I need y'all to really make sure that you built up your case prior to suing. The main thing, your main piece of evidence is in them not replying line by line to your affidavit. When they don't reply line by line to your affidavit, remember that 11-page affidavit I showed? If they don't reply line by line to that, which I've never had a situation where they reply line by line to it, you got yourself a case, you can sue them, right? So like I said, like I was just saying like a minute ago, the goal is to settle in private with a private claim, but if they don't resolve it, we make a complaint, which is public, meaning we're suing them, right? And then like I said, we're gonna be suing pursuant to 1692 KD. This is for district courts, 1692 KD. So the amount you can sue for is up to $75,000. If you want to sue for more than $75,000, you go to the further relief section in 28 USC 2201. So these are the laws you want to be aware of when you write your affidavit. And this helps you build up your case. So when you're writing your affidavit, if you don't have my 11-page one, you're going to want to include these laws. Like I said, I don't talk about these laws on the podcast or anything. I only want it in the right hands. So Rule 55 is default judgment. So Rule 55, default judgment. Write that down and look it up. Default judgment, you want it by the clerk. You don't want it by the judge, because the judge is not there to, help you or anything. Default judgment by the clerk, when you read it, it says a sum certain. A sum certain is basically the amount that you're suing for. And that's what you're going to put in your affidavit of truth. This is your remedy. So Rule 55, when it comes to litigation, when it comes to suing these debt collectors, consumer reporting agencies, whoever you're suing, write down Rule 55, Rule 55, Rule 55, Rule 55. You want to be familiar and be aware of Rule 55. Put that in your affidavit of truth, affidavit of truth, whatever you want to call it. You want to combine Rule 55 with 28 USC 2201A. This is the creation of your remedy. 28 USC 2201A. This is the creation of your remedy. When you combine Rule 55 and 28 USC 2201A, this is where you're able to, get the remedy for the violations that we invoice them for. You also want to use Rule 301. Rule 301 basically says that they have an obligation to reply line by line to your affidavit. So you're just using all these laws to back yourself up to have the best case in the world. And then Rule 602, this is the need for personal knowledge. This basically rules out attorneys from participating in the case. So let me give y'all an example. If you're dealing with a debt collector, you're suing a debt collector. Obviously, with that debt collector, something happened where you applied using your social security card and everything. So in that transaction, the only dealings was with you, the consumer, and the creditor, the debt collector, right? So if an attorney is communicating with you, let's say they hire an attorney, the way to roll that out is use Rule 602. So use Rule 602. If you let an attorney know about Rule 602, they're going to know and be like, okay, this person knows what they're talking about. And they have no choice but not to reply, because when it comes to law, everything's under the penalty of perjury. So for an attorney to come and say and represent them, Rule 602 knocks that out, because they didn't have personal knowledge of the situation, because they weren't there for the transaction. This is why Rule 602 is very, very powerful. So really understand that. As far as formulating it and everything and the proper forms to fill out, you'll have to book a consultation for all that. But, I just want to expose y'all to it if you're not familiar with these rules and, 28 USC and all that. So like I said, also in 28 USC, notarizing. You can notarize with or without the United States. 28 USC 1746 number 1. If you want to sign without the United States, you just have to have 2 witnesses. And remember, quote scripture. You want to use those 9x12 manila envelopes. So when you're sending out your documentation and everything, use those envelopes. Don't be just using regular envelopes. You don't want to be folding papers. You want those big envelopes so the paper can stand in there and not be folded. You want to take this court stuff serious. And you can sue in small claims court. Usually it'll be like $60 a file, or you can sue in district courts. And it's about like $400. If you don't want to pay the $400 to sue, I'm going to give y'all a form. I'm going to reference a form that you can use to fill out to waive that fee. So you can technically sue for free, right? So just do your research and fill out the proper paperwork. Like I said, you can book a consultation if you want more information. I'm just presenting it to y'all. It's a lot of information today. So obviously just pay attention, take notes, do more research later. All right, so when you're suing in district courts, so the forms you want to have is your civil cover sheet. You want to have your complaint for civil complaint form, and you want to have the summons and civil action form. So the summons and civil action form, each company you're suing is going to need this form, need the summons, right? So let me give you an example. Let's say you have a debt collector, they're reporting something on your consumer report that you don't want reported. So let's say it is debt collector 1. Let's call them debt collector 1. So if you're suing debt collector 1, but what's reporting is on your Experian, TransUnion, and Equifax, you need to also sue Experian, TransUnion, and Equifax. So they get the same damages, right? Because they're also participating in the situation. And when you're sending out your notices and when you're serving, you need to send it to every single person, right? Every single corporation or whatever you want to call it. So just keep that in mind when you're doing your summons. You want to send an example. You want to send a summons document to everybody involved. And then, which is optional, this is the form for waiving that $400 fee. So application to proceed in district courts without prepaying, right? So this is what you can submit. These are the forms you basically need to, get this process started for suing, for litigation. And, using these rules, Rule 55, Rule 301, Rule 602, 28 U.S.C. 2201. This is how you get the ball rolling. If you want more information, like I said, book a consultation. But this is just presenting it to y'all. As far as like suing Equifax and small claims court, let me give y'all an example. So what you're gonna need a copy of your statement of claim. So basically you can e-file, so you go online and fill out something. And then basically the clerks, they have to approve of your case. As soon as you fill it out, it should be approved within 5 to 10 minutes if you fill it out right, depending on, how busy they are, I guess. In my experience, like 5 minutes, it'll be approved. And then you have to get 3 copies of the marshal's entry of service document. So you have to send 3 copies of that document. So look up that document, and then you send a $50 money order to the marshals. So that's an example of suing Equifax in small claims court. And yeah, that's pretty much what it is as far as litigation and getting the process started. Any questions as far as that before I go on to the miscellaneous section? This is how you want to start the process. This is how you want to start the process of litigation. It can get really deep, but I just wanted to present it to y'all. Y'all do further research. Make sure you're understanding what the FDCPA is actually saying, and then you'll be able to get your desired result. All right, we're going to go into the miscellaneous section, and then we're going to be closing it out if y'all don't have any questions. So there's a litigation. Let me just leave that up. Okay, so there's questions. So miscellaneous. This miscellaneous information. I want to give y'all some extra laws that you can use besides Title 15 that you can study for independent study. So laws for independent study. UCC 9-210, which I mentioned earlier, request for accounting. 14 days, they have to reply, right? Request for accounting is request for an authenticated record. So them sending you a statement, that's not a validation or verification, whatever you want to call it. When it comes to discharging student loans, 34 CFR 685.215. Use that law, look it up. It's a deeper process. Book a consultation if you want to get deeper into it. 18 USC 1341. So this is a Title 18 mail fraud additional violation. Basically, if they send you a letter saying that you owe a debt, because that's considered a mail fraud. So obviously we focus on Title 15, but Title 18 also has violations you could use based off of them attempting to collect a debt from you. So just look that up and study it more. Rule 55 default judgment, that may be new for some of y'all, like I said. 28 USC 2201, creation of your remedy. Rule 601, remember I mentioned earlier, I said I'm going to tell you a law that says that these debt collectors cannot sue you. Rule 601, if a debt collector sues you, attempts to sue you, they can't sue you by law. Rule 601. So use Rule 601 in your refute of that, your conditional acceptance, whatever you want to call it. Rule 602, need for personal knowledge. This is the law that says that attorneys can't participate because they weren't there at the time of the transaction. So attorneys is only speaking on hearsay. The word, look at the word attorney, attern. It means to attern, so twist words. They're only operating on hearsay, right? So Rule 602, it'll get them attorneys out of here. So just remember that. 12 USC 83, banks cannot loan money. Banks cannot loan money, right? So 12 USC 83, this will be important when it comes to like dealing with those financial institutions with whatever credit card stuff you have. 12 USC 1431, banks are borrowers, you are the original creditor, right? So these are laws that you want to study independently and go from there. All right, so let's talk about disputing a traffic ticket, speeding ticket, I said. So disputing police policy officer giving you a speeding ticket. So Rule 2 is what you want to look at. Rule 2 talks about one form of action. It's basically talking about them pulling you over, trying to give you a speeding ticket is a civil action. So the whole process about disputing is a little bit deep as far as actually disputing the speeding ticket and successfully and getting it, dismissed and all that. So like I said, book a consultation if you want to get deeper into that process, but I'm here to get y'all started. a little bit more deeper than what I gave on a podcast. So you want to use Rule 2 and 15 USC 1692 as your foundation for your defense. So 1692E, right? False or misleading representation. So you want to use 1692E and Rule 2. And what you got to understand is that police officers, they are debt collectors by federal definition, right? So nothing they do can be considered criminal. You got to understand that. Nothing they do can be considered criminal. This goes back to Rule 2, one form of action. They're doing a civil action because they work on behalf of the city, which is a corporation. Register on Dun & Bradstreet. Those of y'all that know DMV, businesses are registered over there. Remember, everything is interstate commerce. So they gave you a ticket without due process. That's where the violation is, and it's a violation of the Constitution. It goes a little bit deeper, but if you look up Rule 2 and you go from there using 1692E and you send your disputes to the appropriate parties, you can definitely successfully dispute that speeding ticket appropriately. And remember, you can, because they're a debt collector, they've assumed the role of a debt collector. All those violations we talked about, that's money. So yeah, just be patient with yourself in the process and you'll be able to figure it out. All right, so some miscellaneous notes too. I want y'all to remember, sign your documents in blue ink, not black, because that means you're a dead entity. And you want a thumbprint in red ink, like I said before, because that authenticates your signature. Red ink pad authenticates your signature. You can get obviously blue pens from like Office Depot. I got a red ink pad also from Office Depot. So maybe they're at Staples too, but Office Depot, you can get all that. Remember, notarizing without the United States is 28 USC 1746, number 1. You want to quote scripture, Matthew 18:16. You want to have 2 witnesses if you want to sign without a notary. But if you want to just keep it the notary way, that's 28 USC 1746, number 2, which is signing with the United States. If your remedy exceeds $75,000, like I said, there's a further relief section in 28 USC 2202. Remember, you want to use 28 USC 2202A with the Rule 55 default judgment when it comes to getting your remedy pursuant to 1692K. Remember, we're looking at D for district courts. Best practice, send out notices to the registered agent address, like I showed you in the affidavit. This is just reminding you stuff. Invoicing, like I said, should happen after an action. What is an action? An action is they delete that item from your consumer report. An action is it's been 14 days and they didn't reply line by line, right? So that wasn't an adequate response. That is an action. That's when you want to invoice. But if you invoice before that, because you're a consumer, you're allowed to make mistakes. You're so powerful as a consumer. So don't be scared like, oh, dang, I did it wrong. All you got to do, send out an additional invoice. I made a mistake in a previous notice. This is the invoice for you, right? With litigation, you want to go after everyone involved. So that goes back to the example I told y'all with Experian, TransUnion, and Equifax. If they're all reporting that information that the debt collector is reporting on your report, right? Don't just sue the debt collector, sue all of them. And you're gonna see on the forms, they're gonna have defendant 1, it goes up to 4. So you can sue, all parties involved. And then litigation, the venue that you're gonna sue the debt collector in is where the defendant does business. This is why when it comes to litigation, when it comes to being successful with these consumer laws, you have to be good at research as well. And a lot of this research is just Googling the Secretary of State. You can even call them if you want and ask them where they do business. And yeah, look up their registered agent address. So that's pretty much it. If y'all have any questions, let me know. Some final remarks. While I give you guys a minute or 2 to ask any questions, I'm gonna make some final remarks and then we're gonna get out of here. Hopefully y'all got value from tonight. So some final remarks, take action. So there's a lot of information from the literacy to, litigation. I want y'all to have grace for yourselves, but take action. Don't just hear the information and be like, oh, it was all the sauce and all that, but not taking action. I want y'all to focus on taking action. Y'all took action by investing y'all hard-earned money and being here tonight. So take action by going further and actually, taking action as far as a process, whether that is sending your affidavit, whether that is going to court, whether that is booking a consultation with me just to get clarity on, what you need to do. You don't have to book a consultation, obviously, but obviously it'll make the process quicker. All right, don't get overwhelmed. Like I said, it was a lot of information presented today. Maybe what you got to do is go back to the foundation, which is understanding the literacy of the Fair Debt Collection Practices Act. We went over so many violations and things like that. So yeah, just really understand that. All right, and then I will send those that purchased the replay within 24 to 48 hours. If you did not purchase a replay and now you change your mind and you want to purchase a replay, just send me an email, a DM or something. I'll send you the link to actually purchase the replay because it was a lot of information. And I'm going to email y'all, those of y'all that's on the live class. So if you're watching this on the replay, you're not going to get this, but I'm going to email y'all the PDF FDCPA document that I showed y'all that has everything on one page. All right, so that is it for me. Does anyone want to come off mute and give a testimonial just about the process? If you're like shy or something, or if you don't want to, come off mute, what you can do, you can record your testimonial like 30 seconds or something and email it to me separately. But any questions or anyone want to come off mute and give a testimonial about their process, let me know. Let me know. I'm gonna give it a couple minutes for any questions, and then we're gonna get out of here. Let me know. Or if you want to come off mute and give a testimonial. Remember, you can, if you're shy or if you don't want to give the testimonial right now, you can record it as soon as we get off this and then just email it to me at michael@catactics.com. I hope y'all got value from tonight. I hope you learned something. One gem you can implement to help your situation. And yeah, that's basically my hope. I hope that y'all can take action and execute. Any questions? I'm gonna leave 1 minute left if y'all have any questions. If y'all have questions later, I know it's a lot of information to digest, that is something you can do. Somebody said, what did I mean about combining the affidavit? So I think your question is talking about when I said that you can, do I have the administrative thing open? Okay, I don't have it open. But basically, with the affidavit, you can send your notice and default opportunity to cure, everything just in the affidavit. Everything just in the affidavit, your debt validation, everything can be in one notice. You don't have to send it separately, like as a whole administrative process. That's what I meant. Hopefully that helps. Hopefully I answered your question. But if there are no other questions and no one wants to come off mute and give a testimonial, I hope y'all can email me a quick video testimonial. I hope y'all got value from tonight. And yeah, we'll go from there. Y'all have a blessed one. Let me stop sharing and let me stop the recording.